Right. Moderator, can we go back on the record here?
All right.
Okay. Before we move on to number 8, I'm going to direct us to do a roll call of the board members. Machiko?
Cora Damian.
Yes.
Dr. Buhari.
Here.
Dr. Jensen. Claudia Mercado.
Present.
Andrew Marino.
Present.
Dr. Patel.
Here.
Denise Pines.
Here.
Okay, let's move on to agenda item number 8, and this is discussion and possible action regarding hearings pursuant to Business and Professions Code 2307D and 2452 and Section 2 of the Osteopathic Medical Act, and we'll have Michael Knotts, our legal affairs. Go ahead and present.
Good morning, Mr. President, members. Michael Knotts, OMBC Legal Counsel. Your new executive director has asked to put this matter on the agenda today to discuss the manner in which the board has hearings for petitions. As you're all aware, at times individuals whose licenses have been disciplined file petitions before the board. Individuals, licensees who have had their license revoked have the ability to file a petition to have their license reinstated. Individuals who are on probation have the ability to file a petition to either modify the terms of probation or to end their probation early. There are 2 methods by which boards can hear these types of petitions under Business and Professions Code Section 2307D, which is a portion of the Medical Practices Act that's applicable to the board. Either the petition can be heard by the board acting as the agency itself, or it can be heard by an administrative law judge. And the board can then review that decision as it does other disciplinary decisions and has to respond within 100 days. There are a couple pros and cons of each approach. The board traditionally has heard petitions sitting as the board itself, where you will have an administrative law judge sit, provide over the hearing. The respondent will appear in person or these days at times via video conference. The Deputy Attorney General will be present along with the respondent's attorney if he or she has one. And the hearing will be conducted in front of you as a board. I think the pro in terms of that method is the board has the ability to view the petitioner, has the ability to ask the petitioner questions and sort of evaluate in person their thoughts on rehabilitation. The con is that it does take up a substantial portion of your meetings, and at times with other boards it leads to multiple day meetings depending on the number of petitions they might have. In terms of the method of having a administrative law judge hear the petition on their own, that certainly saves a lot of time for you potentially at board meetings, but you don't have that ability to view the petitioner in person and ask questions. But it certainly does create a lot of efficiencies, and the board still has the ability to review the proposed decision, and if the board is concerned about that decision, has the ability to reject that decision, request the transcripts, and we would then sit in closed session and go through the testimony and discuss whether the petition should be granted or not. So I think if there are any questions, I can certainly entertain those. I think what was anticipated here is for the board to potentially have a discussion on how they wish to proceed. I think the default method probably would still be for you to hear these as a board in person. But I think your executive director is probably looking for a motion if you want to change that and have these matters heard by an administrative law judge. So with that, I will turn it over to the board for discussion.
Any comments from our board members regarding this potential motion?
I had a question for council. Just to kind of reiterate myself, can you tell me the process again? The decision to go with an ALJ or the board, that's the decision of the licensee, correct? Is that...
Well, it's truly the decision of the board in terms of how they want the matter to be heard.
Okay.
So whatever option the board chooses provides the due process that the law requires in terms of providing the opportunity for the licensee to petition the board for either reinstatement or to make changes to probation.
Okay. And then just for clarification, we provide them the option of either taking their matter before the full board or with the ALJ?
We don't provide that's for the board to decide. We don't provide that option to the petitioner. That really is an administrative decision that can be made by the board. Either way, their petition's going to be heard. There's going to be an ALJ present, either presiding over the hearing as a full board, as we've done in the past, or there would be a separate hearing that would happen under the Administrative Procedure Act as in sort of the normal process of how ALJs hear discipline cases and other cases.
Okay. I just wanted to get clarification on that from him.
Absolutely.
I had a question too. So are you saying that it's a case-by-case basis, ALJ versus full board, or are we trying to decide as a whole, are we going to do it this way versus this way? Or is it based on the particular matter?
It can be done on a case-by-case basis, and over the course of the pandemic, there are a lot of boards who normally would hear petitions in person, but that we're sending them to administrative law judges. It can be done on a case-by-case basis, and that would be within the discretion of your board president. But I think and maybe your executive director can speak to this. I think what she's looking for today is just some direction in terms of what direction you'd like to go, if you'd like to make that a decision in terms of how you would handle these by default, basically.
I could provide my opinion. I've been in purview with some of these matters, and it was a very fulfilling experience, and I think it's particularly rich for the respondent too. I think going before the full board would provide, I don't know, just a more comprehensive look. I know we want to be efficient, and I know that in the past that we have integrated these hearings in our meetings, but one thing that we could do if there's a backlog is consider having just a full day extra meeting where we do hearings. Just my thoughts.
Erica Calderon here. Just to chime in a little bit, we do not have a backlog on petitions, and historically I did have a conversation with Corey, and this board doesn't seem to have very many petitions. So we can definitely continue with the current process. I think the discussion was, or the idea of bringing it against the board to make a decision on this was a lot of boards are moving towards sending their petitions to the administrative law hearings. I'd like to say, to add to Michael's explanation, you don't have to adopt these proposed decisions, and that's where it comes back to you. And at that moment, you can actually request that they provide either a written argument or present themselves in an oral argument upon the board. So our ALJs are trained for these types of cases, and I think that was a decision as to why we wanted to have this discussion. It's just to have a little bit more time in our meetings, especially with all these projects coming on board, for you to make the choice. We do, I see the value of both ways. And the situation in here is that you do have that ability to non-adopt and bring them to a hearing upon the board.
Just to add to that, that's a very good point in that if the board reviews, if we did send it to an ALJ and the board reviews the decision and wants to hear and see the petitioner, the board could offer, can't require, but could offer the petitioner the opportunity to come and present oral argument. So that's a good point, and I just wanted to highlight that.
So if we had questions after reading transcripts and going over the case, we could still request the in-person answers?
So there's an opportunity to provide either oral or written argument if the board rejects the decision, and that's sort of how it would proceed. The board would reject the decision, the matter would be set for another closed session, and but it would be up to the petitioner whether or not they provided oral or written argument. So there's an opportunity there at least.
And then just so I can understand the process and completion, from my understanding, when we receive a decision, a proposed decision by an ALJ, that does not always necessarily include transcripts, right? That would be a separate process if we wanted to review transcripts. Is that correct?
Correct. The process would be if you review a proposed decision and the board decides that it wants more information, wants to see the transcript before making a final decision, then we would reject the proposed decision and order the transcripts, and then the board would look at those, review the entire administrative record, and make a decision. At times, that may be the same decision that was suggested in the proposed decision by the ALJ, but the board has the opportunity to review all the evidence.
So right now, when there's a petition from a licensee that's been disciplined, we only know about it from them showing up here in these meetings, correct? So how would we be notified that there was something that was handled by an ALJ at an administrative hearing?
You would receive it as you do other disciplinary decisions through your mail vote process, and then you'd have the opportunity to vote on it or hold it for discussion at the next meeting.
And is that based on the majority of the members, whether or not we go one direction versus the other?
Correct.
I'm wondering if you could just also speak to what was anecdotally you've heard some of the rationale the other boards have. You mentioned, Director Calderon, that some of the other boards are leaning toward that. Have you heard as to why that may be?
From my experience talking to other directors, they are fully aware that going in front of an ALJ, they're receiving that hearing. Our Attorney General's office represents us in those cases, and they bring their legal counsel. After the proposed decision is drafted, then it comes to the board. So, again, going back to the idea of you being presented the case, and if you decide to hold it, you can. There are some matters where it's the slam dunk situation where you don't have to necessarily bring them in. And so I think that's what the purpose was, to kind of give you an option for you to decide which matters to hear and which matters that you're okay with adopting as proposed.
Anecdotally, just to add, I've also heard that as a result of the pandemic, the availability of court reporters to come to in-person meetings and has been at times limited. At times, they're much more willing to attend the video Teams or WebEx type hearings. So that's, I think, another issue that's been driving that. But there was definitely a trend over the course of the pandemic to refer more cases to the Office of Administrative Hearings to be heard by an ALJ, but that was really a matter of logistics in the times when we were shut down.
But I think most of the members of the board, we appreciate the in-person experience because it allows us a level of opportunity to be able to sort of look at the authenticity of the petitioner and to get a feeling towards what they're asking and whether or not it's reasonable, and things like honesty and body language. Those sometimes do get taken into account. But if we're not losing the ability to still have that in certain cases that aren't slam dunk prima facie cases, then I think that's probably, it may be reasonable to adopt the motion. We can think about it.
I guess my thoughts are if there's not a backlog, it just provides a richer experience and it would prevent the back and forth too. I just feel like if I got a document on my screen or on a piece of paper, it can't take the place of somebody in front of me. And these are very serious matters. These are licensees that want their licenses back in most cases, and it's a huge decision. And I feel like coming forth towards the full board is probably the best case scenario as we've done in the past, especially if there's no backlog.
We've got comments from other board members. Well, all of them, everybody wants to comment. So I'll start with Dr. Jensen, if you want to go ahead and speak first.
I would just echo exactly what was just said. I think that it gives both the physician as well as the public more transparency in the issue. I think it gives the opportunity to really understand what's going on, and to have both sides truly be heard and respect the severity of the issue at hand. If we have no backlog, which I don't believe that we do, Erica said that we don't. I have never seen that we've had a backlog in these in all the years that I've been with OMBC. I think that it is a more thorough process. But I would also be interested in what perhaps Ms. Pines would say, as she has been on another board, and if she's had that experience. I've never had the experience of just getting the report. I agree with Dr. Buhari. I like being able to actually ask questions and interact with the applicant.
Yeah, I'm totally in agreement that we should keep. There's something about of humans and what we can see and interpret, hear someone's testimony. Kind of the distractions that one can have when we are really able to focus and actually hear that testimony. And I also agree that I think the advocates and the patients and the people that come to our meetings have a right to be in person for something that
Denise, your audio is cutting in and out.
Oh, okay. Sorry about that.
For the last 10 seconds.
Oh, okay. So I was just saying that that the patients, the patient advocates, and the people that have come that are all wrapped around this particular, petitioner has the right to be in person with this. These are very serious when they get to this level. So I don't think this is something that, and especially because we don't have a backlog. And I don't think we need to add an extra day unless our agenda consistently is going to be full. But right now, I have not seen that this is something that we need to adopt in this way. So I would definitely move for a non-adoption.
Claudia?
Yes, thank you. I would like to make a motion for us to keep the same process and allow the petitions to be heard. With access to the public.
Yeah, that would just be non-adoption of the motion to go forward, because the default is the way we're doing it now.
Okay.
Gord,
can I?
Oh, go ahead.
Oh no, just if I can make. So thank you for clarifying that. So that is my motion, the way you stated it, and I would like to add too that it's also very critical for sometimes the students to be there present. I think they've been in a few of these cases, and we gotten good feedback from them. So I look forward to having them attend some of these public meetings and be able to go through this process with us, with the board. Thank you.
Gore?
I'm also in agreement. Board brought it up already, but I'm also in agreement with having actual meetings.
So I'll make a motion with where's my language? The language would be the motion on the table would be to adopt the change of having the petitioner go through administrative hearing in front of an administrative law judge and us reviewing transcripts before approving as a ballot. Okay, that's the motion on the floor. Is there a second to the motion?
I'll second.
Oh, 1 second.
Yeah, let me just sort of chime in. If it seems like the discussion of the board has been that the board would like to continue to hear these matters as a full board. I don't think we need a motion to accomplish that. So I think we can just move forward and your executive director has that feedback from the board, and
Okay. So we won't be adopting this?
Correct.
Okay.
That is correct. Thank you.
Okay, so, any public comment? Any members of the public requesting comment? Present members? No? How about online members? Moderator?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. I'll pause a moment to allow the public time to access the Q&A panel and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. And we will go ahead and move on to agenda item number 9. And we have some guests. So this is discussion, possible action to initiate rulemaking and amend sections 1635, 1636, 1638, 1641, and 1659.31, and repeal sections 1639 and 1640 in Title 16 of the California Code of Regulations, which are the requirements for continuing medical education, or CME, approval, CME documentation, sanctions for noncompliance, and citable offenses. And we have Terry Thorfinson, our program manager, and Christy Shields, the attorney, legal unit for the Regulatory Review Unit, DCA. Welcome.
Thank you. Go ahead, Christy. Good morning. My name is Christy Shields. I'm an attorney with the Department of Consumer Affairs Legal Affairs Division. I work in the Regulatory Review Unit. I've been with the department since, by way of introduction, since I haven't met you all before. I have been with the department since 2000 in various capacities, board counsel, personnel, in personnel capacities, and employment law, as well as litigation. Currently, I'm serving in the role of what's called a second level review. So when your regulations council sends a proposal forward for review, I look at it as sort of a second eye reviewer and identify any issues that I have, and we try to resolve those before we bring this text to you. So I have been working pretty diligently with your staff on the current proposal before you. I do recognize that you previously approved various versions of this text, and it's been before you several times. I do apologize for that. We have had a lot of different attorneys in this position, and every time an attorney looks at it, as you know, they have a different opinion about what needs to be done. I'm looking at it from the lens of someone who's served in this role for more than 20 years and worked on regulations that entire time. And so I'm going to look at text and proposals perhaps differently than someone that's newer to the department. And so that's why you're seeing so many different changes from the last version you looked at. We've worked pretty hard on this one, Ms. Thorfinson and I, Ms. Calderon, and I'm feeling confident that this is the proposal that I think you might want to take action on today, and my recommendation would be to do that. We have thoroughly reviewed this text. This regulation was most of these regulations were originally adopted in 1988. So there have been a lot of changes to your statutes and laws, and the way the associations even accredit CE has changed since that time. So there were a lot of changes made to come up to speed, so to speak, on all those different law changes, and, you know, in the way continuing education is accredited also had to be changed in this proposal. In addition, where regulations may be cross-referenced to other sections in your division, I added those proposals to this proposal because if the Office of Administrative Law will look when you make a change to one section of a regulation to see how that impacts the other provisions in your division. And so I've added several sections that I think will need to be revised consistent with current practice and the way that the law is currently written. Again, these regulations were adopted originally in 1988, and you, for instance, no longer do review and approve continuing education courses. You take accreditation from the AOA and the AMA when it comes to accredited coursework. So All of those things you'll see in front of you, and Ms. Thorfinson will go over that in detail, but I'm going to ask if you have any questions for me that you would like to ask that I could maybe answer before I turn it over to Ms. Thorfinson.
Any question from board members?
This is Claudia. Thank you so much for putting all this time. I did hear that you say you recommend that we take action today. Is there something else that we should be considering in terms of why this is necessary today for us to take action on this?
Well, I think that I want to move this proposal along for you for several reasons. One is, like I said, the regulations were first adopted in 1988 when there were no statutes to implement your continuing education program. So your staff at that time really developed the program from the ground up. Subsequently, the law was amended in 1989, and it changed the requirements for continuing education courses and limited to courses accredited by the American Medical Association and the American Osteopathic Association. And it specified which category you had to accept in the way of continuing education coursework. The regulations were never revised to recognize those changes. And so your regulations are currently inconsistent with the way that the statute's written. And there have been other changes to that statute since 1989, and the regulations need to be updated to conform to those changes because those are out of date. And your staff really has kind of MacGyvered, so to speak, and dealt with the gaps in the laws and in the regulations by coming up with their own processes and procedures. And we really need to get those in regulation because we have a duty to the public to let them know how we're processing continuing education and what standards they have to meet. Those are currently not in your regulatory proposals that you have, in your current regulations, but this regulatory proposal would include all the processes and procedures we've gone through with your staff on how they're processing proof of satisfactory completion, what coursework information they look for when they're reviewing whether someone's compliant with CE, and all of that, out of fairness and notice to the public, should be in regulation. So all these changes, I believe, are necessary to get up to date and current with the way the program's currently operating and with the way the law has changed over the past almost 50 years. So that's why I'm recommending you move it forward. And like I said, I spent a lot of time with your staff. Has been wonderful and responsive in accepting going down the path of getting extremely detailed and explaining all the processes and procedures and producing documentation for our office to review and help assist in revising the proposal. So with that said, that's why I'm recommending it, because it's currently just completely not consistent with the way things are working. Any other questions?
Thank you. I appreciate that.
You're welcome.
Do we,
okay.
Let's say, what do we do next? Yeah.
So Ms. Thorfinson's going to walk you through a kind of a bird's eye overview of the changes that are going to be potentially made. And again, where we are in the process, just to orient you, because I know sometimes people check out on this, but I think it's important to recognize that we're at the beginning of the process. We're going to go through and explain all the suggested changes. If there's anything you think should be changed, please let us know and we can work on that at this meeting. And then if you approve it, it would just be the beginning of the process of departmental review, and then it would go out for public comment for 45 days. So the public would have additional time to comment and provide any concerns they have with this proposal during that 45-day period. With that said, I'll turn that over to Ms. Thorfinson.
Yes, thank you. Christy has been wonderful to work with. It was a shock to me to see so many changes, but I'm impressed with her work and her thinking and her legal skills, and I wholeheartedly support all of the revisions that we've made together. I want to just remind new and existing board members the difference between a statute and a regulation. The statute, as many of you know, is something that is a creation of law by the legislature. A regulation is something the board can create with authority, either from a statute or our existing authority. So as potentially boring as this topic is, this is your moment to be able to create policy. And so I encourage you to lean into it, stick with us on this one. We've written a really good, I think, model type of reg for this. So it has a lot of detail, and I think, I'm optimistic that it'll be approved when it goes through the process as is. So I want to begin. I have the memo that kind of outlines, gives you some background, gives you the highlights of what the policy issues are, discussion, and kind of explanation section by section. And then I have the addendum is the actual proposed language. And I thought that it might be helpful to first go through the memo, and then when you hear the background of what we're changing, I'm going to highlight what's new and what's existing, that it might be easier to look at the language as we go through it, because it does, the devil's in the details, and that is in the actual language. So, as Christy mentioned, there's been a lot of changes over the years, oddly enough, in CME's area for legislation, and what we found is as this reg went through its process, we kept having to change the draft of the form that we had with this. And we did not realize some of the other sections that were not in compliant with the statutory changes. So one of the things that we're doing is we took away the form that went with this, and we put the citation of the statute itself into the language in Title 16, 1635, so that citation kind of is timeless. As that statute changes, it automatically changes without having to do a regulatory change. And in putting the details that you'll see in 1635 and 1636 that really lay out what are the requirements, that took the place of what we had kind of a one-pager, 1.5-page form. So all of those requirements that we had that would become a form that licensees would go on to breeze and, answer the questions, yes or no, have you completed this? All of that is now in this regulatory language. And that allows us to be able to not have to constantly do regulations as new laws change. And it also allows a lot of flexibility for how breeze, the forms and the questions in breeze are listed. And so that's a major change and approach to this, and it also creates a lot of more words than you've seen in the past. So if you go through, we go through the memo, the background talks about that you have seen this, you have approved this in several different sections. I think the last change was because we were attempting to acknowledge the exemptions to the pain management, the mandatory one-time pain management requirement for CME. And when Christy looked at it, she added more of the statute to it, so it's more accurate. So we called out that exemption that we didn't necessarily do a lot of in the form, so I think it's in a lot more detail. And the regulatory package, basically, to do what we want to do policy-wise, we're trying to shift from a staff manual review of all CMEs prior to renewals, okay, 100% review prior to renewals, to a system where licensees, when they go online, they can fill out this form that certifies, yes, I've completed all the requirements, and I'm certifying that everything I say is accurate, and they submit that, and then that allows them to, if they pay their fee, to renew, okay? Big change in terms of streamlining, time, savings this to it. But then the board is also in this regulation being given the audit authority to go and check for compliance, because we felt good about compliance because we were doing it before they could renew. Now that we're undoing that review before they renew and allowing them to renew themselves, then we need the authority to audit them, and then we give a lot more detail about what information they have to give, in what time frame they have to give it in order to see if people were in compliance. The result is that they would, if people were not in compliance, they would be cited and fined and issued an abatement order to complete the very least to complete the missing CMEs. So that's the policy change. The other policy change I mentioned was that we want to cite the requirements for CMEs from the statute, so that it's simpler and kind of endless in terms of its application, and it doesn't conflict with the statute. Okay, so the main sections that do all that in Title 16, there's 1635, 1636, and 1641, and then I added 1659, which is the cite and fine. We're adding language to that. Those are the main sections that actually do and put into place the authority that we want with the details that we want to make this happen. The other sections that have been added are what I characterize as cleanup sections. Those are sections that, as we amended these sections and looked at the statute, we found that the sections no longer they conflicted with some of the statute, or they refer to a section that we crossed out and renamed and revised, so they no longer work. So in section 1638, 1639, and 1640, those are cleanup language. Okay, so let's go over just a little overview, what we're doing. In 1635, this is the section that specifies the CME requirements for continued licensure. As amended, it updates the requirement to reflect statutory changes through the years, and so it's up to date. It also, as I said earlier, defines what the CME categories and amounts are. Section 1636 is the documentation section. This lists the requirements and acceptable documentation for CMEs and authorizes the board to audit licensees for CME compliance. 1641, this section we didn't change much, but this is the sanctions section for noncompliance. 1659-31, this is the cite and fine section. We just added the 1641 to that. 1638 is the section that provides exemption for inactive status for licensees. We're not changing that. The part that we're changing is subsection E that refers to 1635E, which no longer contains the wording on the categories that it's referring to. So we're deleting that subsection C only. Then section 1639, this defines CME categories. Again, as I said, we're deciding to go with the statute for that definition, so this 1639 is obsolete at this point, and recommending to delete that section. 1640 is a section that provided the board with the criteria and approval of CME programs and CME providers. We've never used this authority. Throughout the years, the board has always looked to the AOA as the expert, and I anticipate that we will continue to do that, and so we're recommending to delete that section as well. Okay, going back to the discussion section, CME requirements. I think I have talked about a lot of the things. I talked about what we did do is we added the description of the statute for the one-time mandatory 12 hours CME courses that needed to be done by a certain time frame. We also added a requirement that the legislature added to our statute through the years, which added a risk of addiction associated with use of Schedule II drugs to be completed every renewal cycle. We had not called this out in the past, It just really kind of came to our attention during this regulatory review process that this is a requirement different than the one time. This is a requirement that licensees have to complete every renewal cycle. And there was kind of, I did provide some input at the time to the legislature, but they did not take that input. They wanted to they were very much, if you remember, during the heat of the opioid crisis, very intent on feeling like they were, doing something in their power to control the opioid crisis. And so they put it in our renewal statute, which then makes it be something different than a one-time. So as a result, we're also putting that in 1635. Yes, go ahead, Chrissy.
I would like to point out in the draft on page 2, if you look at D2, that's where the description is of the course requirement. We are leaving open the time required for it, so it'll be up to our interpretation would be up to the individual osteopathic physician what length of course they want to take. I think my experience, typically 1 hour is the typical course time frame, but it just says they have to take a course on the risks of addiction. We're not mandating specific time frame for that. So I just want to call that to your attention. That's the proposal on page 2, D2. It also describes the minimum course content. Of course, it could be different, but the minimum course content is also prescribed here, and that is also true of the 12-hour CME pain management course. The course content would be set forth, the minimum course content would be set forth in this proposal at D1.
Good clarification. Also new in this 1635 is that we add details specifically about which individuals would be eligible for an exemption to the CMEs, different than the statute that provides inactive licensees an exemption. This is for ones that want to stay active but want to be exempt, and we have never really defined those. We attempted to in the last change, but we're providing a lot more detail, including a definition of direct patient care. So among the details or areas of exemption that we're calling out, we knew about it from our last draft. The pathologists and radiologists would be exempt, but what we didn't include was licensees not engaged in direct patient care nor provide patient consultations, licensees that do not reside in California, and then we did not provide a definition of direct patient care, which we did in this text. When we get to the text, you'll see that definition. Go ahead.
Just for clarification, so this is for exemption from the one-time 12-hour requirement, and these exemptions are derived from statutes, so we don't have the ability to really change those categories of exemption. We're just providing some additional detail as to what direct patient care means, and we're putting all the exemptions in one location so that the licensees can easily find the list of exemptions in one place in this regulation.
Good clarification. That's why we're both up here. Okay, so I wanted to move to 1636, the required documentation and audit requirements, as I call them, but this is where we put in our authority to audit, and we changed the word from report to documentation because that's what we're really looking for. So wording of documentation and disclosure are the action words in this section because it characterizes what information is required to be provided by a physician. So if it's not, that would be non-compliance with this section. So that definition and specifics is intended to provide licensees notice of what information are required. The section prior to that is also notice to what the requirements are that need to be met. And so this section is giving specific language about what is required and when. So one of the things that is new is that we're listing the specifics, we didn't before, and we're listing a time frame that that licensees, when they receive contact for an audit, they would have to respond to the board within 65 days. usually response is a kind of an open-ended, kind of unenforceable situation. So by putting in a date, a number of days, it provides a determination that the person is either compliant or non-compliant. We're determining that to be 65 days. And then a prior unchanged requirement is that licensees retain their CME documentation for 6 years from the completion date of courses. That's not new. We approved that before. Let's see. And then because this is electronic, we wanted to have language that essentially, even though you're not signing it, it's electronic, you are under law making a certification of the truth of what you're putting down in the form, which is actionable. So that part, we're adding certify under penalty of perjury, the statements and the disclosures that will be used in the audit to determine compliance. We kind of had that in the form, but now, remember, we're not doing the form, we're putting it into the documentation section. Go ahead.
So previously, all this information was on a form that you were prescribing that everyone had to fill that exact format. The value of putting all that information kind of in a narrative statement format is that you have the flexibility of allowing people to submit the information in multiple ways. There's no one specific way that they have to submit it. And then over time, if things like, for instance, if the form had letterhead on it and the governor changed, we would have to go to the Office of Administrative Law and fix that form and get it approved. You won't have to do any of that if it's in the narrative format and they can submit it in any format they like. So I think that's a lot more flexible way of approaching this, but also meeting the needs of getting to self-certification, because the idea is to move from kind of this investigative pre-review of CE, where the requirements are met, to a self-certification format where people are just self-certifying, they completed the CE, and then you audit them to make sure they actually did. That's actually pretty standard across the department, the way that the boards manage CE compliance. So, like I said, like Ms. Thorpenson was indicating, the reason why it's so wordy is because when you have to write it out in a narrative format, it takes up more space on a page than just a question and answer on a form. But getting rid of the form frees you up from being tied to a specific format and allows you to implement across different formats and allow licensees multiple ways of meeting the requirement and not having to keep updating that form. So that's why we opted to go this route.
Good clarification. Okay, I'm going to move on to section 1641, sanctions for non-compliance. We made very few revisions, but I want to call out a few. We did change references to any references to 1635 because they're no longer accurate. And then the non-compliance, I want to call this out. Non-compliance has always been considered unprofessional conduct, and cite and fine was added as a possible consequence for non-compliance. We do that with many of our violations. We sometimes have both a cite and fine component and an unprofessional, more disciplinary component. What's new in the language is that it was just, non-compliance was limited to 1635, and the way we are wording it is that even violations of 1636, which is the documentation requirements of disclosure, also would constitute a violation. And the reason that we went down this path is to create an accountability in this process, because the board was very reluctant to give up this kind of control of before people are licensed, making sure that they complied with this section. So it's very important to have a strong enforceable audit process so that there's no ambiguities. People either they know what they need to complete, they know what the process is, and if they don't follow that, it could be a violation either based on the content, the efficiencies of CME, or it could be based on the lack of documentation and information required. So that's new. Okay, and just briefly, the cleanup sections, I think I went over those, so I won't go over those again. They're just changes because of the changes in both the statute and the sections of 1635, 1630, and 1641, those changes necessitated some repeals and amendments. So the last one is 1659. 1659, let's see, where do I have that one? Did I skip that one? Oh, yeah. I'll go over 1659 because it's just a little phrase. But what we added, 1659.30, to the cite and define section, or giving us the authority to cite and define, we added 1641 to that. Okay, so I'm going to skip over the recommended approval of this and go to the language so you can get a feel. Christy's already kind of walked you through a little bit of it. If you look on page, the separate document, so it's got its own pages. If you kind of skip through 1635 to page where you get into the meat of what we added. First parts, like page 1, we're striking out, those are not new. Where we start to add the new stuff is on page 2 in D. And we talk about meeting the requirements of subsection D as a condition of renewal. Okay, and then you'll see 1 talks about defines the 12-hour CME requirement from section BMT code 2190.5 within 4 years of initial license or by their second renewal, whichever occurs first. And then we start to define a little bit more detail. At a minimum, the course content in pain management shall include practices for pain management and medicine, palliative, and end-of-life care for terminally ill and dying patients, and, this was the new part, the risk of addiction associated with the use of Schedule II drugs. Those were all statutory changes that we're incorporating into here because it's important, both from the administrative law judge looking at, not administrative law judge, the Office of Administrative Law, looking at have we given licensees that are held accountable notice of what the requirements are. Exactly, not vaguely. So that's why we start to put in some real detailed description about the course content. So B is the course components involving the risk of addiction associated with the use of Schedule II drugs mentioned in subsection D1A. At a minimum, the course content shall include regulatory requirements for prescribers and dispensers, strategies for identifying substance use, and procedures and practice for treating and managing substance use disorders patients. Okay, now the reason that kind of detail is in there is for licensees to wonder when they're taking CMEs that they want to will it comply with this requirement. You can see there's quite a broad array of topics that would satisfy this requirement that we didn't otherwise have described in our prior regs. These are intended to try to give broad parameters, but yet specific enough to know when you're shopping around for CME which one might meet that requirement. And then CME earned shall count by the board towards the CME requirement in 2454. That wasn't, I think that was obvious, but we're making it clear, leaving nothing to the imagination. And 2 is the course risk on addiction. We again call out what those minimum courses are. And we allow that it can be, they can still get credit in B, as Christy mentioned, that if they take a course in the 12 hours, it can course in that renewal period, they can get credit for that risk of addiction, because the one-time courses have 3 subjects that would satisfy that 12 hours. So for one renewal cycle, if that's the renewal cycle, you do the 12 hours, you also meet the risk addiction for that one. But then ongoing, you still have that risk addiction requirement. Okay. And then E, the new E, talks about the exemptions in specific. Who's exempt from meeting these requirements? And basically, the first one is pathology or radiology. The second one is physicians not engaged in direct patient care, and this is where we add the definition. meaning no personal or face-to-face interaction with a patient, including health assessments, counseling, treatments, patient education, prescribing or administering medications, or any task authorized by the Act or described in sections 2051 or 2052 of the, we say the code, the Business Profession Code, that involves personal interactions with the patients. And 3, physicians that do not provide patient consultation or physicians that do not reside in California. These first, third, and fourth come from the statute. The second is something that we're adding for clarification on what the definition is. 1636, medical education documentation. I'm going to skip down to the meat of it, subsection B, and we use the words disclosures, documentation and disclosures. Documentation would be the information that we're requiring to demonstrate compliance. Disclosures would also be like in totality all of the communication, including emails or back and forth clarifications, that is also going to demonstrate compliance with the requirements. So to capture that in more detail, we're listing it out. What do those mean? Okay, you can see the name, license number, mailing address, telephone number, email. And then we specify the requirements of the 50 hours. This is in the statute. And we, again, talk about the one-time pain management, like we did in the other section, again, leaving nothing to the imagination. We also talk about the exemptions again, because we're defining what kind of disclosures they need. And then 5, whether during the 2 years preceding the license expiration, they've completed course on risk addiction. This is an every year an every cycle requirement. And certify under penalty of perjury. And then the C starts to talk about our authority to audit and the requirements. I mentioned 65 days. That's in the C. Retaining D requires people to, licensees to retain their documents 6 years from the completion date of the course. And then what do we accept for documentation? A copy of the, and these are based on what we already accept. But we add a little more detail, licensee name, because believe it or not, people leave blanks in our materials. So we don't want people to leave blanks in anything. CME courses reported to the AOA is one. Another one would be transcripts, AOA or AMA. And 3 would be AMA accredited courses earned from any CME courses. Those would have to be documented with the following requirements. Okay, I've already gone over, I think, the ones why we repealed these. So I want to just skip to that citation section, which is on page 9, 1659.31 citable offenses. And we added, if you see the first 2 paragraphs, we added the underline, this is the new wording, or upon any other grounds listed in section 1641. So that gives us a citation authority for the CMEs. It also, for future sections, because our citation, we have to amend in a separate packet. And one of the things that Christy's advised that I think is good is to go away from listing every single section, because to revise this, we're going to have to add, not in this package, but in a future package, 20 or 30 sections of the law that we want to have a citation authority. She's recommending if we do it more like by the article that is more inclusive in a paragraph form, that we can have the same authority. And Christy, you can.
Yeah, I think that we can talk about that at another meeting. This one, we're only recommending for this section to add or upon any other grounds, because if you read the way it's currently written, it talks about under what violations you can issue a citation for. And because we're adding at the end of 1636 authority to issue a citation and fine for violation of a CE requirement, we then have to carry over a cross-reference to the citation reg that specifically says, oh, and for a violation of the CE requirements, the executive director can also issue a citation. So we have to make sure that whenever we change one section, we look around to see how it may impact other sections so that everything works the way you intended, which is to make sure that you have the option in lieu of disciplinary action to do a citation for a violation of continuing education requirements.
So that concludes my presentation. So I'm looking for 1, questions, and 2, a motion to approve, and Christy can guide the motion.
Yeah, I'll talk more about the motion, but I first want to ask if the board members have any questions about any of the proposed changes.
Yeah, I have a question. Have we clarified the CME reporting period? I know that was a major source of confusion in years past. I might have missed it, but I wanted to clarify that the reporting period is 2 years immediately prior to expiration, not the last 2 calendar years.
Right. We got rid of the calendar year, a kind of misalignment in one of the prior statutory changes, so now they're identical. The CME renewal cycle and the renewal cycle are the same.
Got it. And I know that the AOA defines Category 1 CME. My understanding is that physicians or licensees that have students, they're not exempt from CME, but that's considered CME. Is that correct? Or is that more of an AOA question?
I think that's an AOA question.
Yeah, that's an AOA question.
So the original regulations set forth what kind of AOA and AMA and AOA accredited coursework you would accept, but then the statute was amended to indicate that it had to be AOA Category 1, which means continuing education activities and programs approved for Category 1 credits by the Committee on Continuing Medical Education of the American Osteopathic Association. Now, with respect to AMA, American Medical Association accreditation, it does not specify it. So they can take anything that's accredited from the AMA to meet this requirement. Your current regulation says it has to only be Category 1. So we have to fix that to allow, to make sure it's clear that the statute allows them to take any type of AMA accredited coursework to meet this requirement. So that's one of the
That's for the 30.
In subdivision C, you see it struck in this proposal on page 1.
That's what he's asking. That's for the 30 AOA.
Right, that's for the 30.
That's for 30 AMA.
The 20 AOA has to be Category 1.
Yeah. Does that answer your question?
My understanding is from teaching medical students, I think that's Category 1A. Is it 1A? It is. Okay. Yeah, and when you submit those hours and you get the credit for them, it has to say that.
Correct. I mean, we have put in here the documentation requirements that your staff's currently requiring, and so we want to mirror what's being done so that everybody is aware and on the same page as to what the requirements are for showing proof of satisfactory completion. So that's also covered in this proposal.
And we do get variations initially, particularly on behalf of residents, that sometimes the first time the submission of the letter doesn't have enough information, so there is a back and forth. There is not going to be the opportunity unless somebody proactively, contacts the board for that back and forth, because right now we catch things. After we do go to this, self-certification process and self-renewal, they are claiming that they've completed it, and if their documentation is incorrect, they have to live with that. So that's why the specificity in this reg is supposed to be giving them the notice of what do they actually need exactly.
And you probably want to do outreach when this is being implemented to make sure that people are educated as to what they're actually going to be submitting to prove compliance with continuing medical education requirements.
And one other thing, you went over this in detail, but for my brain. So the 12-hour CME course in pain management, treatment, terminally ill dying, that regulation, that is every 2-year cycle or just the one time?
One time.
Just the one time.
Go ahead.
With either your first
your
licensure
first
or initial
licensure
renewal.
Period, yeah.
Okay.
So A one-time, it says on, if you look on page 2, one-time 12-hour CME course in the treatment within 4 years of their initial license.
Right. And that matches
Their second
statute.
renewal date. That's
Yes.
statute.
Okay.
Yes.
2190.5 of the Business and Professions Code. Then 2454.5 says that the licensed osteopathic physicians and surgeons shall complete a course, doesn't say how long, on the risks of addiction associated with the use of Schedule II drugs. That would be a requirement, prospective requirement, that would need to be completed after the 12 hours. So if you do the 12-hour course during that renewal period, you wouldn't have to do then another Schedule II risks of addiction course. But the next time you renew, you would have to have taken a course in Schedule II drugs, risks of addiction associated. And it would need to meet the minimum content requirements. And this, from what we've been able to determine from staff and reviewing other courses that are out there, this is pretty standard as to what the content would be at a minimum. You can have other types of subject matter in the course, but at a minimum, we're asking that the course include it says this in D1B is that the course content includes regulatory requirements for prescribers and dispensers, strategies for identifying substance use, and procedures and practices for treating and managing substance use disorder patients. And so that's pretty standard course subject matter for these types of courses. I don't think there's going to be they're going to have a hard time finding courses that meet that criteria. If there's anything else in the subject matter, they can take that if they choose in their own professional judgment to take that.
Any questions from the board members for our presenters?
This is Claudia. I just want to thank you for all the detailed work you've done. I don't have any questions. It seems like everything has been done with a lot of attention to detail. So that's me. Thank you.
Thank you. So my request to the board, if you think the text is acceptable as presented, do you do your motions before public comment or after? I'm not sure what your process is.
If there's going to be a motion, I think we can just hold public comment on and have that on the motion, so we don't do it twice.
Okay. So this is going to be a little bit long, and I'm sorry, but over the years, the Office of Administrative Law has gotten more picky and more, prescriptive as to what they want to see in the authority by the board to move a regulation proposal forward. So the proposal, if you think the text is acceptable as presented, is to approve the proposed regulatory text to amend sections 1635, 1636, 1638, 1641, and 1659.31, and repeal sections 1639 and 1640 as set forth in the meeting materials. Direct staff to submit the text to the Director of the Department of Consumer Affairs and the Business, Consumer Services, and Housing Agency for review, and if no adverse comments are received, authorize the Executive Director to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for a hearing if requested. If no adverse comments are received during the 45-day public comment period and no hearing is requested, authorize the Executive Director to take all steps necessary to complete the rulemaking and adopt the proposed regulations as noticed.
Okay, so we need a motion stating that.
Yeah, I'd like to make a motion as stated by our legal counsel.
Okay, motion is there a second? Okay, the motion is there and seconded. Now we'll take public comment on the motion from our present members. Any members of the public want to comment on this? Moderator, any online members of the public wish to comment on the proposed motion?
This is the moderator, and at the direction of the board, I have opened up the Q&A panel for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. We have a motion on the table. Machiko, can you do a roll call vote for us, please?
Yes, Doctor. Gord Damian,
Yes.
Dr. Buhari,
Yes.
Dr. Jensen. Sorry, was that a yes?
Yes.
Claudia Mercado,
Yes.
Andrew Marino,
Yes.
Dr. Patel,
Yes.
Denise Pines.
Yes.
Motion carried.
All right, the motion is carried. That was a tremendous amount of work.
Yes.
Thank you.
Thank you.
Thank you, Christy.
You're welcome.
All right, we can move on to agenda item number 10, which is discussion of implementation of plans for 2022 legislation. And we have Terry Thorpenson, our program manager, again.
Doing that. Okay. Again, I want to just thank Christy and all of her help. I think that, you know, we waited a long time for this to be a successful package, and I think it's in the best shape it's ever been in. And it's all thanks to her. Okay, so I have two documents for this ledge presentation. One is the short one that just is the list of the bills that we followed, and I wanted to show you the outcome of those in terms of did they pass and become law or not. That's the purpose of that one. And the second document is the implementation plan, and this is new, something that both Erica wanted more detail compared to what I have given you in the past. And so we had gotten some of the information from DCA, which also kind of prompted boards to think about these bills in terms of what are you doing to implement them. So that's the purpose of the second document. So I'm just taking, I'm not going to go bill by bill on the first document, but I tried to highlight in colors which ones didn't pass versus which ones did pass. So you can see that not everything passed. I think from a, I don't know, a spectator, if you will, perspective, you wonder, wow, when a policy gets proposed, does it have any chance of passing or not, or did it pass? That's what I think this at a glance look at these bills does. So among the ones that, even though it's at the bottom, it's at the top of my next document, is our proposal to the legislature, which was to eliminate our prorated license fee and eliminate the proration cycle for initial license. And that was signed into law, so that's huge. I've been counting on the calendar for the day that it became into effect. It's just huge. I think even people at DCA were cheering about this one, so I'm glad that this went into effect. Some of the ones that I'm glad didn't, the AB 662, I thought the board did not really like this. It was really more problematic in terms of what it was trying to solve, and this was trying to address people with convictions that were applying for a licensure. And the process of what they were proposing really didn't make sense. It was like a double process of application. You know, with nothing that held, people could still reapply and appeal and stuff. So that was good that that didn't go anywhere. The mandatory reporters was a good bill, but didn't get through. I don't know why it didn't have support. That was the warm touch idea that physicians, you know, didn't put them, because they're mandatory reporters, in a bad position. It kind of helped them out in terms of what role they played. Didn't criminalize their non-reporting, but that did not go into effect. And So let me go to the document 2. Okay, 1443, this was a sunset bill for somebody else, but it was a vehicle for our change, for eliminating the prorated license fee, which I think everybody is familiar with. And but I want to just reiterate, particularly for maybe some of the newer members of the board, is that over the years we have been, through legislation, been chipping away and simplifying our rules with respect to initial licensure as well as renewals. And we used to have a really complicated system when I joined the board in 2016 that I still couldn't really explain. I had to rely on my staff, which required like 3 years of CMEs, but we only had a 2-year renewal cycle. And then prior to me, we used to have just an annual renewal cycle. So we went to 2 years. Then we got rid of the 3 years, put the CME cycle into 2 years, but then we still have, as Dr. Patel mentioned, that we still have the idea that we had a calendar year cycle for the CME and a license expiration cycle to determine the 2 years. They were both 2-year cycles, but they were not, you know, there was like a Venn diagram where there was some overlap, but it wasn't exact. So what ended up happening is that people didn't realize that by December 31st, they had to have their CME done. And they didn't have until they expired. And so getting rid of that ambiguity has helped, I think, clarify when all the CMEs are due, period. Okay, so that was a prior change. The last change, I think, was this, which is that the initial license was based on what they call a birth month. And the idea behind it was that people wouldn't forget when their license expired because it would be sometime in their birth month, because nobody forgets their birthday, right? But what it caused is varying license periods that we had to do a regulation that defined that somebody could not be licensed for less than 12 months or more than 24 months. Okay, so then Breeze, to do that, Breeze then auto-calculated. Well, when that Breeze change came, it created a lot of havoc. And among the things it created is that if someone didn't pay in the same month that they billed and the calendar month flipped to the next month or later, now the amounts are different. Breeze is charging one amount, their check, they're getting billed based on the letter they got from us in a different amount. Caused a lot of workload that was unnecessary. And so when last year SB 806 requirements came into play and changed the time frame for eligibility for licensure from 36 months to 12 months, that's where this prorated license cycle became problematic, because what happened is that some people didn't complete their 36 months at the time of their first renewal, which is when they're supposed to demonstrate under SB 806 that they've completed 36 months of postgraduate training. Well, so then what? Well, so then we had to allow for it so that they could get renewed in their first renewal, and then they would have to demonstrate in their second renewal. So now we have 2 sets of people. Some people are demonstrating at their first renewal, some are demonstrating, 3 years after. And so that was one of the driving forces from getting rid of this prorated cycle. The Med Board doesn't have that. They have, so it's a very known process. When you get licensed, you have 2 years. At the time that you get licensed, you're likely, under that scenario, when you apply, probably going to have completed your 36 months. So there's not going to be variation of some people having to wait for 3 years and some people, renewing. So that compliance, it created some really kind of iffy statutory compliance, which we thought we'll just get rid of by this. So that eliminates that. Workload-wise, huge elimination in terms of cashiering, refunds, and all of that went along with that. It's also very simple. 2 years, you're going to be charged upfront, full license for 2 years, and it expires after 2 years. So in terms of what we had to do to implement this, The implementation required that in Breeze, we are setting Breeze so that we no longer have the prorated cycle. We only have one fee. We don't have a varying fee, because Breeze also kept varying the fee by month. So we turned that off, and so that has been in place since January 1 of this year. And we're still going through transitions because people that had what we call an open transaction where they had been billed an amount, if they didn't pay by the time it switched to the January 1, it did in Breeze. And so then they had a different amount like we had before. So we're still working through those, which I'm hoping we're going to be done in January from doing that. But with any transition, there's always a little bit of a transition. But thereafter, everybody that is applying and being billed after January 1, it's just going to be under the new law. One amount, 2 years. We also sent a policy alert for licensees about all of the changes in the 2023 laws that went into effect. We emailed it, and we have that on our website. So that's another way to outreach as far as we have in our ability to notify people about that change. So that's part of our implementation plan, if you will, on that bill. Any questions? Okay, I'll go on. That's the one that's ours. The rest of them are just bills that somebody else brought that we're going to have to implement. So I think of them differently. I have fondness for that 1443. Okay, so the AB 657 Cooper expedited licensure process for physicians providing abortions. I think there was a package that the governor and the legislature put together in response to the Supreme Court overruling Roe v. Wade, and they wanted to make, in ways that they could, make the law easier for physicians and to kind of confirm that that's still right. So there was a ballot initiative which passed that confirmed the right. So one of the bills was to expedite licensure process for physicians that are coming in and applying for licensures that can document that from their employer with a letter that they are coming to California to provide abortion services, so they would be eligible for this expedited license process. Again, the implementation for that included Breeze. We have a modifier like we do with military and other expedited processes, and we also included that in our policy alerts on the website and sent out by email. AB 1636 is a certificate of registered sex offenders. This is one more strict requirement that the board can't reinstate people that have been convicted of sex offenses, and this is adding to an enforcement policy. The board, I think the legislature is responding to the feeling that boards were not, may have been reinstating or not revoking somebody that was convicted and a sex offender, and they wanted to make sure, take that out of the discretion of the board and make sure that the board cannot undo this. This is the policy. By law, you don't have discretion on this one. Again, this was in our policy alerts and our website. We also implemented a violation code in Breeze. The next one, it didn't get signed into law, so 1954, treatment of and medication of patients using cannabis. I guess this was an issue that patients were being discriminated against based on their use of cannabis, so it's trying to do two things, trying to prevent that discrimination, calling it out, and also trying to give cover as best you can legally to a very legally ambiguous subject area, which is that it's okay, it's legal in California for physicians to use medical marijuana and prescribe it. Now, it doesn't change the fact that federal law still considers it illegal. So this law is trying to provide a little bit of cover, but in the end, federal law always supersedes. So it's a good attempt, and we also have a enforcement code for that. We haven't gotten any complaints about this, so this is just something that I guess the legislature was made aware of. Okay, AB 2098. This is the unprofessional conduct regarding dissemination and misinformation of SARS-CoV-2, COVID-19 unprofessional conduct. And this bill, the board had discussion about this bill. It did go into law, so it does make it an enforcement violation for if there's a complaint related to misinformation or disinformation about COVID-related cases and treatment. And the board also disseminated this through their policy alert website, and we did a breeze code for an enforcement violation. AB 2626, Calderon License Discipline on Abortion. This bill was part of those abortion services package that reaffirmed, because as the states around the country were banning abortion services, they were also outlawing and prosecuting doctors. And so California wanted to kind of confirm that doctors can't be prosecuted for just simply providing abortion. Now, that's different than if they're negligent, because then it's based on negligence. But just simply providing abortion, which is true in a lot of the states that ban it, they can be prosecuted very seriously. So this bill is just reaffirming that we can't prosecute doctors, not that we have, but we can't prosecute doctors simply for performing abortion. This was also sent out in our policy alerts on the website. Mandatory reporters I already talked about. SB 89 already went into effect. That's why we can have this meeting in a hybrid form. I wanted to, though, bring it up to you that it was only a year that the legislature gave us for this open meeting hybrid scenario. So DCA's encouraged boards to keep advocating for the extension of this to create the greatest flexibility. So that is something I think that in conversation with the board, that you guys like to be in person, but you also like the flexibility of the hybrid. And I think in terms of agenda posting, it creates the greatest flexibility for us, because having that location have to be public and posted and not change could make a meeting not be able to happen. So that was an old one. That went into effect with the budget in January, but it was on our list. Criminal release, SB 731. This was part of expanding types of arrest records that are eligible to be sealed, part of the reform on kind of the job and conviction reform about people with past convictions to try to make them better eligible for jobs. This one is on the list because it affects us, and I want you to know that there is a law that allows some eligible applicants that have convictions to be able to apply to have those convictions sealed, and so those would not be on our applications. I'm thinking they're not on won't come up as rap sheet hits either. So this is going to be significant for those that it applies to. We are not, this is a Department of Justice implementation. This is just something that I want you to know that is happening, because it is a trend in terms of the legislature's support for this. SB 923, gender affirming care. This expanded cultural competency for continuing medical education to include individuals who identify as lesbian, gay, bisexual, transgender, queer, questioning, asexual, gender diverse, as part of CME cultural competency type CMEs. And the idea is cultural competency requirements was a way that they were trying to influence doctors who studies have shown may have a bias that they're not aware of, and that through taking and training on cultural competency, it makes them maybe aware of a hidden bias. Well, the same thing is true for gender-related patients, and so they're expanding that definition. This is not under the mandatory section of CME, but it is allowing any CME in this topic to be acceptable. for any of our requirements. Also, we mailed that out, notified licensees of this change. SB 1237, military service. This bill clarified that that California National Guard members that are on temporary assignment outside the state are eligible for the benefits of the military license, the fee waivers and stuff, even though they're out of state. Because in the past, there was a feeling that it was being only given to those that are located and assigned in California. And this is trying to expand that understanding that because they're California-based, but they're in another state, they still would be treated, and then they're seeking licensure in this state, they still would be treated to the same eligibility standards as if they were being in the state as military personnel. And non-conventional treatment, that didn't go anywhere. Bills not on our tracking list. I included these because just to inform you what other bills that impacted physicians. This one is deals with phlebotomy, and there was a change in their scope of practice. And so one of the things that physicians need to know is this change. They're supervising these people in some cases, and so they need to know that they can do this particular procedure. Last but not least, AB 1278 opens payments database reporting of gifts. This bill linked kind of a mandate to a federal database where physicians are already required to report any kind of gifts that they have from corporations that provide pharmaceuticals, durable medical equipment. But this bill requires that they provide notice to their patients of it. So it's kind of like the notice to consumer law. The notice to consumer has to tell the patient that you're licensed by our board, and that and the second part of the bill was that you can also, this is if you want to file a complaint against your doctor, you can, and here's where to contact. That's that notice. This is a new notice that will be telling patients about this open database, whether your provider or you use it or not, you still have to provide the notice. That's effective as of January 1 of this year. And effective January 1 of next year, you have to post it on any website physicians use for their practice, this kind of notice. I have gotten questions on this, particularly telemedicine. It still applies. There's no exemption for telemedicine. The notice has to be done. Just because the visit is virtual doesn't change the rules in terms of what you have to do. So this is new. I did specify this in our policy alert, the very detailed wording of the options. There are many options of how you can provide patient notice. So I recommend people going to our website to look for that specific notice, or contact the board if they have questions. And that concludes my ledge report. Any
Thank you,
questions?
Terry. Any questions from the board members?
This is Claudia. For future references as these bills come up, is there a way for us to stay more engaged? I know we talk about these on our quarterly meetings, but is there any way that we can see what the staff is working on a regular basis?
I don't understand the question.
So I think in terms of how the legislation works, I think the legislators are going to start drafting new bills, I believe, starting March, or they're going to start working.
Oh, okay. Uh-huh.
So if you can maybe explain to us how that process works and when you get involved and then when we as a board members get involved.
Oh, I see. Okay. The calendar, if you will, begins kind of in January, where legislators introduce bills. Roughly around the third week is the deadline for initial bill introduction. And then they have to have authors and some kind of content. It can be placeholder language by February, the end of February. Then in March, the first policy hearings in the legislature occur, and the Rules Committee determines which which committee or committees hear bills. And so so bill hearing starts in March, April, May, and then with an idea there's a little break in January for the budget discussions and negotiations to make that deadline of, June 15th or so for the budget to be signed. And then they resume hearings, and the calendar for a bill has to go through, if it enters one house, like Assembly, it has to be to pass the Assembly and all the committees, including the Appropriation Committee, by, generally the goal would be by July, although there can be lateness, because then it has to go through all the committees' hearings process in July and be wrapped up in August for floor votes, and any changes have to be voted on the floor. So in terms of our timing, we used to have the meetings. It's kind of tough meeting-wise to be able to respond because when we have May meetings, we may have missed the actual policy hearing for the first house. But that doesn't mean that we missed the second. There's another policy opportunity in the second house after that. But a lot of times the challenge is if we have, I think, we change our meetings from May to April so we could be more responsive, that will give us the opportunity potentially to weigh in on bills before the first hearing, okay? But sometimes the constraints is if they don't have the bill fully worded, they're still negotiating it, and so it goes through the first house, they have minimal wording, maybe we don't have an understanding of what it's going to be. And suddenly, after like in June or July, we see all this new language suddenly being dropped into the bill. Okay, well, we might have already reviewed it, but now it's totally different. Now they have different language because everybody's been negotiating and proposing language. And so that process of trying to capture the right moment of when to react to a bill is somewhat elusive. But the idea of moving our committees to April, in theory, gives us the opportunity to look at bills topic-wise that might be of interest to us and consider whether we want to watch it or take a position on it at that point. And it doesn't preclude us not, when we find other bills, to consider taking positions or reviewing those later in the year. We could, if it was very serious, we haven't gotten to that point, but maybe we do feel that way, is to try to then have a meeting for a particular bill we want to take a position on. Usually those types of positions are for opposed bills because if we support it, that's easy to convey that support. So we then last year changed we had a second meeting in which we got an opportunity before the ledge season closed out, so they still were voting. We had a meeting to come up with positions. And then those positions were conveyed, and then the legislature closed out, the governor reviewed and signed or didn't sign particular bills. So I think timing-wise, we have our meetings, the two meetings, if we still keep with the April and the August as good timing to consider bills and participate. One of the challenges, honestly, has just been we don't have the staff to dedicate to really track legislation and get involved. I have gotten involved in bills, and I think I've mentioned this to you in the past, or not, I work closely with other board staff, particularly the Med Board staff, ledge person, and he usually alerts me to bills that are problematic for both boards. So when I get that kind of language, I contact the author's staff and say, listen, here's our issue with this bill. And this is even before we've taken a position on it. This is just something proactively that's going to be problematic. And a good example of that open meetings bill was one of the original bills that was put on my radar screen that I talked to the author about. But it wasn't in that format. It was in a format where they were wanting to restructure the expert reviewer for enforcement contracts, which would have just put a work stoppage in terms of enforcement. And so I called them and said, listen to what are you trying to do? And then they explained that they wanted to do this open payments legislation. And I said, well, you should do that. But you got to take this language that's going to really mess up our contracts. They have nothing to do with that. It's a different process. We got a different system through DCA. You know, you just need to take that out. So they took out that language, and I pretty much, once they did that, I kind of ignored the bill. But that was an example. I didn't necessarily bring it to the board. I didn't have time. I just reacted because it would be detrimental. I do that proactively behind the scenes. But for general stuff, when it's a policy position, I don't. I'm not proactive. I wait until the board makes a position. So we do have some capacity to be proactive, but there's room for improvement. I mean, more time, and this is something that I think Erica's talked about and wanted, is to have more of my time dedicated to legislation. I have experience. I've done lobbying before. I've run policy organizations, government affairs, programs. So I know how to do this stuff, and I can jump into action. I just need the time to be able to do it in addition to all my other stuff. So I hope that answers your question, Claudia.
No, thank you. I think that's informative for the board and also just for the public. So I appreciate you going through that process. I really think it's important for us to be involved in the legislative process. So thank you for your efforts.
It is, and I will add that in some of the implementation of bills, one of the things I do is I have to do a fiscal analysis for the department and an IT analysis on what the bills would require. And I flag on both something that is going to cost us money or is something that's going to be really cumbersome to implement IT-wise. And we're dealing with a bill now that IT staff said, how come you guys didn't take a position on the bill? And that was, a problem. It's causing, I think it won't in the end cause us too much heartache and expense, but for some boards it is, and they didn't take positions. So it's just kind of a lesson that there is a kind of a consequence in not being really involved in the legislative process. One of the advantages of having a ledge person like the Med Board does is they proactively meet with legislators. They create legislative packets. And so, one of the familiar questions I get from lead staff is, what is a DO? Which section are you in the statute? Are you included in my bill? And a lot of times that's one of the input is like, hey, you need to also mention osteopathic physicians and surgeons in your bills if you wanted to apply to us. So we haven't done a formal kind of legislative program, and we should be. But staffing is kind of the limitation at this point, and something Erica's looking into.
Yeah, and just really briefly, I do come across some bills because I am involved with some other organizations and do legislative work, and I have seen that where there's a bill that mentions the medical board, and then I read through it and it doesn't mention us. So what I hear from you is that we need to actively inform the legislative body of who we are as an entity and why including us in their bills or asking us for a position could be advantageous so that the process is smoother and just more just, correct? To service all of California members.
Claudia, this is Erica, Executive Officer. Just wanted to chime in here that these are some of the ideas of other positions that we are looking into bringing onto the board. We are working with our budgets department to see if we can bring an RA to assist with the legislation and regulations of the board. We do have a couple of regulatory packets that we do need to bring into compliance. And we also have our disciplinary guidelines that haven't been revised for several years that are also in the horizon to needing some updates. So with the budget change proposal coming up in spring, the idea of putting together an RA to assist with these in these matters is definitely an idea that we're looking at right now.
Thank you, I appreciate that.
Any other questions from board members for Terry?
Michael Knotes, legal counsel. I have something very briefly in the form of a very brief legal news flash in terms of SB 1237 and licensing of military personnel and their spouses. On January 5th, 2 weeks ago, President Biden signed H.R. 7939, the Veterans Auto and Education Improvement Act of 2022. And that one of the many things that law does is create license portability for professional licenses for service members and their spouses. So that's going to supersede a great deal of our laws that have to do with military licensing. It is going to allow service members and their spouses to practice with a license provided by another state with certain requirements that they submit to the licensing authority in the state where they're practicing in terms of discipline and other things. But that's a really big development, and I think the department is going to be looking at how to implement that, because military members and their spouses will not need to obtain a license from boards and bureaus in California. So that is all.
Wow.
Okay. So we'll entertain public comment from any members of the public that are present. We have a question.
Holly, would you like to come up, please?
Apologize. I'm Holly McChrist. I'm with the OPSC. I'm the executive director. One question I just have is, in all the legislative work that you are doing as this board, how are you interacting with OPSC, seeing how that's a very big part of what we do as well? I see lots of partnerships being able to be had here, seeing how your side is fighting for patient care and our side is fighting for patient care and physicians. So I'm just curious to know if that's something that's part of the plan, is to engage OPSC.
Great question. I think this is great for our quarterly meetings. We can definitely bring those to the agenda and discuss in the future. You know, Terry is essentially going to be allowed to focus a little more in that area, and then with bringing on help to help her along as well when we onboard our new management team to handle the other programs. Mm-hmm.
Any other comments from members of the public here? Seeing as though there are not, the moderator, can we check and see if there are any online public comments requested?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. Okay, I think we're going to take this time and break for lunch before we get to agenda item number 11. Yeah, we'll try and make it a quick one, just 15 to 20 minutes, okay? So we're at lunch right now. That's okay. All right, we're back in session after lunch. Why don't we go to agenda item number 11? Oh, sorry, we have to take roll. Machiko? Yeah, let's do a roll call.
Okay. Board Damian.
Yes.
Dr. Buhari.
Present.
Dr. Jensen.
Yes.
Claudia Mercado.
Present.
Andrew Marino.
Present.
Dr. Patel.
Present.
Denise Pines.
Here.
You have a quorum.
All right, well, we'll continue on with the meeting. Agenda item number 11 is Intergovernmental Relations Reports and Administrative Services Update. And we'll get this DCA update from Judy Bucciarelli with Board and Bureau Relations DCA. Welcome. Oh, the button here.
Dr. Bahari, we actually had a change to the agenda. We have Melissa
Oh,
Gear.
sorry. I'm an idiot. I'm reading the wrong.
The
old one.
We have Melissa Gear.
Melissa Gear. Sorry about that.
Yes. No problem.
Apologies.
No worries. Yes, and hello and good afternoon, Executive Director Calderon, President Bahari, Vice President Jensen, and members. Happy New Year, and thank you for allowing me an opportunity to provide the DCA, our Department of Consumer Affairs, update today. So, as you know, I am Melissa Gear. I am the new Deputy Director for Board and Bureau Relations. I was appointed by the Governor in October. Prior to my arriving here at DCA, I was the Chief Deputy Legislative Director at the Department of Insurance. I also have worked at several other departments, including the Department of Justice, the Department of Education, the Legislative Analyst's Office, as well as the California State Teachers Retirement System, or CalSTRS. And so I am bringing all of that knowledge and policy background here to DCA in hopes of helping to continue to protect consumers and work and learn from all of you. So I am excited about this opportunity. So thank you. I'm also excited to announce the Governor appointed Yvonne Durantes as the new Assistant Deputy Director for Board and Bureau Relations, as she most recently worked at the California Office of Emergency Services. So we are now a complete team of two, and we are looking forward to getting started. We also have another announcement. We are pleased to announce the appointment of Kathleen Nichols as Chief of the Division of Investigation. She was sworn in on December 5th. Ms. Nichols has extensive law enforcement experience with over 28 years of investigating and supervisory experience. The department has begun the process to fill the Deputy Chief position in the Health Quality Investigation Unit. I'd also like to share an update on the DCA Diversity, Equity, and Inclusion Steering Committee. The department established its first Diversity, Equity, and Inclusion Steering Committee, or DEI committee, to guide the department's equity strategy, initiatives, and action plans. The DEI committee held its official kickoff meeting on November 9th, and its second meeting will be held later this month. Additional resources will be forthcoming that all boards will be able to use and incorporate into their strategic plans, recruitment processes, and et cetera. The committee will concentrate on three key areas: workforce, to help find and keep diverse talent; workplace, to actively educate leaders and employees to raise awareness and foster an inclusive culture; and marketplace, to be sensitive to the diverse backgrounds and perspectives of consumers, applicants, and licensees. Additional update is related to our strategic planning to more effectively advance equity and drive outcomes that increase opportunity for all strategic plans for July 2023 and beyond. Must be developed or updated in accordance with Governor Gavin Newsom's executive order. DCA is revising its strategic planning processes to include more inclusive public engagement, data analysis, and the incorporation of DEI into strategic planning. The DEI committee will provide input to strategic planning processes in the coming months. DCA will begin implementing the revised processes and working with boards in updating existing strategic plans or developing new ones by March 2023. DCA released its new strategic plan in November, and we officially transitioned to a new logo on January 3rd, 2023, which you'll see on the screen. The new logo will be implemented gradually throughout 2023. Existing items with the previous DCA logo are still valid during the transition and do not need to be replaced or updated. DCA board and bureau leadership have been given information and resources to help with the new logo's implementation.
A centralized website is also available at www.dca.ca.gov/logo, which is what you'll see when you go to that website. The new plan and logo represent the department's next chapter and future, with consumer protection continuing to guide our mission and priorities. DCA holds itself to a high standard as a licensing entity, regulator, educator, and service provider. Additionally, the plan incorporates our strong commitment to diversity, equity, and inclusion, as well as our shared commitment to each and every consumer. The new logo not only displays our state's official colors, but it also visually represents the DCA's vision, together protecting California consumers. The shield symbolizes DCA's strong and long-standing protection mandate. The state symbolizes all 40 million Californians DCA has pledged and is honored to serve. The star symbolizes consumer protection as DCA's strong guiding principle, its own North Star. If you have any questions, please contact me, and I'd be more than happy to answer them. Also, appointment information on how to apply for membership in a Consumer Affairs Board. The first step to becoming a board committee or advisory committee member is to submit an application to the office of the appropriate appointing official. There are 4 appointing offices: the governor's appointment, Speaker of the Assembly appointment, Senate Rules Committee appointment, or an advisory council or committee appointment. For details on vacancies and who appoints members to a particular board, review the Department of Consumer Affairs board member roster. For more information on activities and membership for a particular board, visit the board's website. Links to board and bureau websites are available on the DCA Boards and Bureaus page. All board and bureau appointees under the Department of Consumer Affairs are subject to term limits with grace periods of varying lengths. Most members can serve up to 2 consecutive 4-year terms and a 1-year grace period. However, appointments requiring confirmation by the Senate only reserve a 60-day grace period. Only governor appointees on these boards require Senate confirmation. For Professional Fiduciaries Bureau, which I'm not going to go into because that doesn't apply, but there are additional instructions for that. The contact information for the 3 primary appointing offices is also available on our Board Members Resource Center. Once an application is submitted, the governor's office will handle the remaining process. And if you have questions, you can contact BBR. Board member travel. As travel resumes, keep in mind that all state travel arrangements must be made through DCA's authorized travel agency, Cal Travel Store or Concur. When traveling by air and on official state business, all board members and staff must use the most economical fares possible. Typically, this is the Southwest Want to Get Away option. However, if the flight is changed, there may be additional charges. Flight changes for personal convenience are not permitted or justified, and the traveler is responsible for any associated changes. Please contact BBR if you have any travel questions. Required board member training reminders. Now is the time to go over all the necessary member trainings and submit your certificates of completion to your executive officer and DCA at memberrelations@dca.ca.gov. Board members must complete Board Member Orientation Training, or BMOT, within the first year of appointment or reappointment. Ethics training within 6 months of appointment and every 2 years thereafter. Sexual harassment prevention within the first year and every 2 years thereafter, and DCA does their sexual harassment training on the odd years. And defensive driver training within the first year and every 4 years thereafter. For your convenience, these trainings are offered multiple times a year in a variety of formats. For more information, a mandatory trainings page has been created to help members identify, access, and track specified trainings. The page includes direct links to mandatory trainings as well as pertinent information and policies specific to these training courses. The page is available via the DCA Board Member Resource Center page under Required Board Member Training, and you can reach out to either myself or Yvonne. And as we take a look ahead, we're getting close to wrapping up. We have our President's Day training, our President's Training on February 22nd, 2023. DCA invites presidents and vice presidents to our President's Training on February 22nd, 2023 from 10 a.m. to 12:30 p.m. This virtual 2.5-hour training will outline the role of a board president, including understanding the scope of the role, managing board members, and performing administrative duties. More information will be available soon. Also, end of COVID-19 state of emergency and waivers is February 28th, 2023. The state of emergency and associated executive orders will end on February 28, 2023. Upon the state of emergency ending, active waivers that were issued under the authority of the state of emergency and executive orders will also expire. On behalf of DCA and BBR, we'd like to thank you for your dedicated service throughout the pandemic. Please note, by March 15th, 2023, we have the annual filing of your Form 700. Board and committee members are required to file a statement of economic interest or Form 700 within 30 days of their appointment annually and within 30 days of leaving office. This year's annual filing period covers the prior calendar year, January 1st, 2022 through December 31st, 2022. The deadline for filing is Friday, April 1st, 2023. To ensure compliance, DCA requests that Form 700 filers complete the e-filing by Friday, March 15th, 2023. You should have recently received an email from NetFile with instructions on how to file your annual Form 700. If you have questions or would like more information, please contact me. Board Member Orientation Training, or BMOT, will be held on March 22nd, 2023. Board members, again, must complete BMOT within 1 year of their appointment or reappointment. On March 22nd, 2023, BMOT will be offered as a live virtual day of training and possibly in March on June, in person on June 22nd, 2023 and October 10th, 2023. More information will be available soon, and members can sign up using DCA's Learning Management System, or LMS. And last but not least, thank you all again for this opportunity. DCA and the BBR team look forward to working with you and assisting you throughout this new year. Thank you.
Thank you, Melissa, for that presentation. Any questions from our board members regarding that?
Melissa, this is Claudia. Thank you for being here today and for the presentation. Welcome to the team. I just wanted to advocate here for the board in terms of our need to get our website redone. I know you guys are working to move that forward, but if we can do anything possible to just get that done, I think we did submit our request a couple of years back. And I am reinforcing that because I do believe that we can create more visibility for the profession, hence increase the interest in somebody becoming a medical profession. Because I do believe there are some trends in California that says we do need to have more physicians in the near future. So just wanted to put that out there for you. Thank you.
Thank you, and I will be sure to take that back to our senior staff as well and make sure that we've got this on the radar.
I appreciate that. Thank you.
Any other comments from board members? Not?
Just thank you for the update and welcome to the board.
Thank you.
Any comments from members of the public that are present? Moderator, any members of the public online who wish to comment?
This is a moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. And we'll move on to 11B, our budget update, which is going to be provided by Heather Robinson from the Budget Office of DCA.
Good afternoon. My name is Heather Sand, formerly Heather Robinson. I am the budget analyst with the DCA Budget Office. Renee Milano is also attending via WebEx, and she'll be here to assist in answering any questions you may have. I want to thank the board members for allowing me time to present the board's fund condition statement. Today, I will be speaking to agenda item 11A, I believe. I think when you pull it up, it comes up as 11A. And this is the board's fund condition. This gives you a 4-year view of the board's fund, and I will speak to each section, top to bottom, left to right. Let's see. The first column is prior year 2021-22 actuals. The board brought in a total of $2.9 million in revenue and expended a total of $3.5 million, leaving the fund with a reserve balance of about $4.5 million. This balance becomes the current year beginning balance, which you will see at the top of column 2. The next column is 2022-23 current year. The board projects an estimated $3.1 million in revenue based on workload revenue projections. The board's expenditures are based on 2022-23 Budget Act fully realized and is projected at $3.3 million. This leaves a months in reserve balance of 13.6. This is the amount of time the board can continue normal operations without incoming revenues. Then in the last 2 columns, we have 2023-24 or budget year and 2024-25 budget year +1 projections. These projections are based on the 2022 Budget Act, except for the income from surplus, which is formula driven. Budget year and budget year +1 are assumed realized, meaning the board expends to the full appropriation. I would like to point out that one of the main driving factors to expenditures and the incremental increase in future years is a result of personal service adjustments. These include general salary increases as well as employee comp and retirement rate adjustments. The Budget Office includes an ongoing 3% increase to expenditures on the fund condition statement to account for these ongoing incremental adjustments. Are there any questions on that fund condition? No? Okay, I'm just going to quickly go over the second and third pages. These are just the expenditures and revenues that were brought in fiscal month 13. So they were briefed in the fund condition, but this just gives them a breakout so you can see each line item where everything fell. Any questions? If not, I want to thank you guys for letting me speak here today.
Any questions from board members regarding the budget presentation?
This is Claudia. For the presentation, can you maybe highlight where we need to be paying attention? I know that we're going to be requesting for some additional staff to be brought on board. And there has to be a regulatory process, I believe so. But where in our financials do we have to pay attention to that? If you can just go back to that.
Can you repeat the question?
I think for staffing purposes, if you can go over kind of where we stand now, and I know we talked earlier about bringing additional staff. I think I might have missed that, but where is that in our financials in terms of staffing cost and what we're budgeting for?
Heather, this is Erica Calderon, Executive Director. I can answer that question, Claudia. The funds that are being used to fund those limited term positions are actually coming from allocated funds that we already have for staffing. So as mentioned in my report earlier, and I think it may have not been caught, in regards to that 0.5 medical consultant that we have, we're holding off on hiring that position so that we can fund our limited term manager. So the funds are already part of our budgetary conditions, and that's where those funds are coming from, so that we can go ahead and bring those positions as limited term. In addition, I'd like to point out that we are going to be working on the BCPs at the same time to then make those positions allocated positions in the future. There is enough statistical report analysis numbers that will allow us to go ahead and pose a really good high argument to keep those positions as permanent status going forward. The other position that I mentioned briefly that we were thinking of bringing on was an RA, and again, it would be utilizing the funds from that consultant 0.5 that we currently have already allocated.
Thank you. I appreciate that, you making that connection for us. Thank you.
No other board members with questions regarding this? Any members of the public? Questions about the budget? None present. Moderator, any online members have questions about the budget update?
This is a moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. And we'll move on to the strategic planning objective update, item 11C on the agenda. Machiko Chong.
Good afternoon. Let me get the PowerPoint up. So my initial intent was to put it up here in the room, but it's not working. So for those that are online, you'll be able to follow along with me. As some of you may recall, in the 2019 calendar year, we surveyed board staff, stakeholders, and members to reassess the board's mission, vision, and values, and also update our strategic goals in an effort to streamline the board's continued growth, both internally and as a profession. As we near conclusion of the current strategic plan in place through December 2023, we felt that now was a perfect time to highlight some of the goals that the board has met and those that we are still in the process of trying to accomplish. The measured goals are part of the following 5 areas. Licensing, enforcement, outreach and communication, regulation and legislation, and board administration. Instead of going over each goal individually within the 5 areas as defined, I will just give a brief overview for each section. So for licensing, effective January 1, 2022, the board successfully implemented changes to the CME cycle. The modifications aligned CME reporting periods with the biannual renewal date for each physician, and also reduced the amount of CME owed each cycle from 100 to 50 hours. This change has both aided in decreasing confusion surrounding reporting requirements, which in turn has lowered the amount of inquiries directed at renewal staff, but will also ensure that all impending changes regarding CME reporting are seamlessly executed once the amendments are finalized. Over the past few years, the board has experienced a major increase in those looking to practice osteopathic medicine in the state. To facilitate the current and continued growth within our licensed population, the board requested and obtained approval to establish 3 new positions within the licensing unit. Of the positions requested, 2 of the 3 were for staff services analysts, or SSAs, and the third was a proposal for implementation of a limited-term staff services manager, or an SSM1. One of the SSAs handles the coordination and maintenance of all postgraduate training licenses, and the other will assist with the review and approval of the full unrestricted license type. Both analysts will assist in the modification and maintenance of the BREEZE database and anticipated outreach efforts of the board. The SSM1 will oversee the licensing unit, redirecting the primary oversight of the current SSM1 to the enforcement unit. So for enforcement, quite a bit of change has occurred and is still underway within the enforcement unit, which you will hear about shortly and you've kind of heard about in Erica's report. And with the vast enforcement knowledge that Director Calderon has brought with her to the board, there will be more to come. Since her arrival, Erica has worked hands-on with the enforcement staff, meeting regularly to address many of the goals and objectives that were outlined within the enforcement unit advisory, while also updating the enforcement forms and procedures for further business continuity and consumer use. Outreach and communication. The board realizes the importance of reaching both English and non-English speaking consumers and educating them on their rights as patients. We also realize the continued need to foster a diverse population of licentiates equipped to safely practice osteopathic medicine in California. Thus, the board has actively been working with DCA's publications, design, and editing team to improve awareness of the board via multiple social networking platforms and also update the board's visual presence. Additionally, the board had the pleasure of sitting down with OPSC's new director, Holly McChrist, and in a collaborative effort, the two offices have decided to work together and proactively ramp up outreach efforts within the profession. Both entities realize the importance of early involvement with potential licensees and will collaborate on increasing awareness of changes and updates occurring within the profession through presentations held at osteopathic campuses and via informational videos and documents. Regulation and legislation. As the board progresses in its mission to protect consumers and promote the highest professional standards, board staff have been in contact with DCA's classification and pay, along with budgets, to discuss the feasibility of adding additional positions within the staff. We will soon be looking to bring on a retired annuitant in the impending future to assist board staff with completion of all regulatory packets needing submission. This addition would allow the board to not only better track proposed legislation, but also streamline the implementation process of all proposed statute changes. And lastly, with board administration, over the past few months, board staff have graciously pitched in to execute various in-office projects, which for some have taken them out of their general realm of expertise. These projects have not only decreased with processing backlogs the board has faced in certain areas, but has also allowed staff time to reassess the efficiency of some business processes currently in place and implement others. In addition, the pandemic brought about a change in how the board approached the use of technology, which we're hoping to continue embracing and utilizing, as we reevaluate our presence and accessibility. From the dissemination and receipt of documentation via electronic transmittal to meeting attendance via hybrid methods, the board and staff have fluently welcomed the modifications to their workload and office operations. Do I have any questions?
Just out of curiosity, thank you, Machiko, for that report. Our strategic plan will be ending this year in 2023. When do we need to start preparing for the next revisions or how we want to, proceed?
So we'll actually be discussing that next. Sarah will present the overview of the strategic planning process, but it is set to conclude in December as previously stated. So shortly after this meeting, I will be sending out meeting invites so that we can start planning for that, but we'll go over that with the next topic.
Any other questions from board members? Okay, any questions from members of the public who are present? Moderator, any online public members have questions?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access those features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. And that'll push us right into D, which was a good segue from Andrew Moreno. Strategic Planning Update, the solid planning from DCA.
All right, and then Machiko, if it's okay, I'll go ahead and take over presenter role for this.
That's fine by me.
All right. All right, so welcome. I'm Sarah Ronnie. I'm from Solid Planning and Training Services, and I am a strategic business analyst and facilitator with Solid. I also will have a co-facilitator on the strategic planning process, Tricia St. Clair. Unfortunately, she's not here today. She's helping another program with their meeting today, but she will be part of the process when we get into the strategic planning process. Before I get started, I can go ahead and answer that question about when we can get started on this process. Because your plan doesn't end until the very end of 2023, as long as by December you have your strategic plan approved, we can get started anytime between June or July. If you'd like to get started earlier, we can. But as Melissa Gear mentioned earlier, with the governor's mandate to put in some DEI into strategic planning, we may have to wait until at the very least March while the DEI committee determines what type of questions we need to be asking for our strategic plans. So sometime between March and July, we can get started. So to talk about the strategic planning components, strategic planning kind of consists of 4 questions. And those 4 questions are going to be where we are now, where do we want to be, how do we get there, and then how are we going to measure our progress. To cover the first one, the where we are now, this is going to be an environmental scan and kind of assessing where the board currently is with both themselves, their external licensees and consumer groups, and kind of how they are in terms of like their staff and management. Typically what we do here is we will interview the board members and interview executive staff on the board. And then additionally, a survey gets sent out to licensees and other consumer groups that the board determines. And we ask them questions on how they feel the board is doing on the goal areas. And then after that, I will put all that information into a big report that summarizes all the information and covers common trends and themes that are being popped up with both the board members and our external groups, such as licensees and consumer groups. The where do we want to be? This is going to be, these are our goals. And then also after you review that environmental scan, you'll be coming up with objectives on how you want to improve what you see is wrong in that environmental scan. And during the strategic planning session, myself and my co-facilitator will kind of guide the board on how to create those objectives and work with you all on how to create that. Additionally, your vision can also be the where do you want to be. If you're going to revise your mission and vision for the strategic plan, the vision is kind of an ideal statement. It doesn't necessarily have to be something that you achieve, but it's something that you want, like you sort of want to be ideal. Next is going to be our how do we get there. This is going to be kind of more after the strategic planning session, which is the action plan, where Solid works with the board, executive management, and staff to kind of determine who is responsible for those individual tasks. that are going to go under each objective. So if you have an objective that says you want to, let's say, decrease citations or something. During the action planning stage, well, what we do is we work with staff. Okay, what are the individual tasks that go under how to decrease citations, and kind of list all those out, determine who has ownership over those, and then make sure that there is a timeline on how to complete those, so it's within the strategic plan. And then also this, the how we measure progress, this also kind of ties into the action plan. You will be providing performance measures and success measures. And then during the action planning stage, the executive staff and the board staff will monitor and track all those individual steps and make sure that they're doing regular check-ins with the board. So I also have a roadmap, which kind of also talks about each step that I just talked about earlier. And this is kind of what the whole process looks like in a timeline. So our first step would be setting up that initial meeting. I will meet with Erica and anyone else who needs to be included in that. Kind of introduce and kind of come up with a schedule to determine dates on when we want to start this process and when we kind of want everything to have deadlines. Additionally, at this point, we may want to revisit that mission, vision, and values in case any of the board members feel that those need to be tweaked at all. And then from there comes the environmental scan stage, which, like I explained earlier, we'll be surveying the external stakeholders, OMB staff, doing interviews with the board members. And then once all that data is collected, I will compile and analyze and summarize that data into a nice fancy report that's easy to read. And then that report is given out to the board members at the very minimum 2 weeks before the planning session. So that gives you enough time to look it over, review, come up with any preliminary objectives that you want to bring to the strategic planning process. And that part is very important because if you do the homework beforehand, it makes the strategic planning process a lot easier and faster. Some boards end up having to go a full 2 days for their strategic planning process because there's a lot of discussion if they didn't get a chance to look at it beforehand. So coming to the strategic planning session prepared is very helpful. Which, bringing us to the planning session, during that we'll go over the environmental scan results just as kind of like a refresher. We may do revision of the mission, vision, and values at that point if the board desires. And then at this point, we'll go over each goal area and then establish objectives for each goal area. Once that's all complete, I will draft the strategic plan and then send it over to Erica for review and any adjustments if needed. After that, the board approves, and then the board will then publish it on their website. And then once it's published and approved, I will work with the board staff to do action planning, which once again will be assigning specific tasks that go under each objective. And then that plan gets reviewed by the executive officer, and then they're given a nice fancy tracker that'll help them kind of keep track of the status of each step and how the status of each objective. At this point, are there any questions from the board members?
Any questions from the board members regarding this process? Nope, I'm not hearing any.
Okay.
Any questions from members of the public about the strategic planning update? None from the public members here. Moderator, any online questions?
Sure. And this is the moderator at the direction of the board. I've opened up the Q&A feature for public comment. If any members of the public have a request for comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. All right, and seeing none, would you like me to close the Q&A panel?
Yes, please.
All right.
Thank you. We'll move on to agenda item number 12 from the division, an update from the Division of Investigations Office. Kathleen Nichols, our Chief of the Division of Investigations.
Yes, good afternoon.
Yeah.
My name is Kathleen Nichols. I'm the Chief of the Department of Consumer Affairs Division of Investigation. It's my pleasure to provide the board an update on the Health Quality Investigation Unit, also known as HQIU. The mission of the Division of Investigation is to protect California consumers and licensees by effectively and efficiently enforcing laws, regulations, and professional standards. Division of Investigation investigators are highly trained in conducting specialized investigations with an emphasis on violations of the Business and Professions Code, laws that govern most DCA professional licenses. As of January 1st, HQIU has 21 investigator vacancies, which is a 25% investigator vacancy rate. We have continued to be diligent in our recruitment efforts and currently have 16 candidates in background and 1 investigator who started on January 12th. We are holding continuous hiring panels to identify additional candidates in order to fill the remaining vacancies. The second week of our 4-week mini academy for newly hired investigators took place last week. This specialized training for investigators includes detailed modules for all the different case types that they will be investigating. 14 new investigators are attending this mini academy cycle. The remaining weeks will take place in January and February of 2023. All sworn investigators have attended training pursuant to Senate Bill 230, which required the Peace Officer Standards and Training Commission to implement a course of instruction for the regular and periodic training of law enforcement officers in the use of force. Training topics included statutory law, case law, agency policy, reverence for human life, de-escalation techniques, duty to intercede, and rendering first aid. The training courses have been ongoing since September of 2022, and all HQIU investigators have completed the training as of December of 2022. In addition, all investigators and supervisors receive training on investigations going to the Expert Procurement Unit for expert review in September and October of 2022. This important training focused on the quality of our investigations and included details of the process for ensuring that all vital information is obtained before the case is sent for expert review. And to give you a brief understanding of our new Expert Procurement Unit, which was implemented in October of 2020, in the past, HQIU sworn investigators handled the expert process for the cases referred. Given the goal of reducing investigation timelines and workload for sworn investigators, we developed a new unit using existing HQIU positions for analysts to locate, screen, prepare expert packages, and receive written opinions from experts. The unit is staffed with a manager, SSM1, and 5 analysts. As part of the review process, the EPU manager reviews and ensures all the records are certified and all pertinent information is included. The HQIU deputy chief also reviews all of the cases submitted for expert, and this combined in-depth review has improved quality standards for our investigations. By shifting this part of the process to EPU, it has allowed investigators to focus on investigating remaining cases assigned to them and has resulted in lower caseloads for sworn staff, which was needed. Another efficiency effort we have made is creating a new non-sworn unit for HQIU as part of our enforcement support unit at DFI headquarters. We converted 3 sworn investigator positions to non-sworn special investigator positions to work the less serious, less complex cases for the Osteopathic Medical Board, the PA Board, and the Podiatry Board. The unit was formed in August of 2022.
We currently have 2 out of the 3 investigator positions filled and will be interviewing for the 3rd position in the coming weeks. This will assist the board in reducing investigative costs and let the sworn investigators focus on the more serious cases. We hold monthly meetings with board's enforcement staff to discuss potential cases for our new non-sworn investigative unit, in addition to sending a monthly automated report with case status updates on aged cases. We look forward to our continued meetings with board staff, and this concludes my update. I'd be happy to answer any questions you have.
Thank you. Any questions from board members or comments? Any comments from public members who are physically present? No. Moderator, any public comment from online members?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Yes, please. All right, thank you for that update. And the next item on the agenda is an update from the Attorney General's Office with Gloria Castro, the Senior Assistant Attorney General of Health Quality Enforcement Section, Civil Division, Attorney General's Office. Welcome.
Can you hear me now? Good afternoon. It's a real honor and privilege to be before you. I wanted to just introduce myself. I'm Gloria Castro. I'm the Senior Assistant Attorney General of the Health Quality Enforcement Section. We're a section that is given the task to manage 8 healthcare oversight agencies exclusively, all dealing with the medical and healing arts only. And you, the Osteopathic Medical Board, is one of our clients, and it's a real privilege to be in front of you today. I want to thank Ms. Calderon for inviting us to be here to provide you an update today. Of note this quarter for the Attorney General's Office, the 6th Attorney General's Annual Report on Accusations Prosecuted for the Department of Consumer Affairs Client Agencies was published on January 1st, 2023. Our report is issued pursuant to Business and Professions Code Section 312.2, and it is available on the Attorney General's website at http://oag.ca.gov publications. And the prior 5 reports are also there for each of the prior 5 fiscal years, and it tracks closely accusations received by our office and certain volume and metrics on average days for completion of important milestone tasks. And as always, the Health Quality Enforcement Section works very collegially with every member of your staff. Your executive staff here at the Osteopathic Medical Board enjoy a high level of communication. And I would like to say that Ms. Calderon has hit the ground running. I've already met with her on several occasions, and obviously we're here today at her invitation, and you will shortly hear from one of my deputies. We meet frequently with the Office of Administrative Hearings to assist them in managing your litigation calendars and your work in front of that board. In front of the ALJs, the Administrative Law Judges. We continue to work with the Department of Consumer Affairs Health Quality Investigation Unit, and will likely begin working with the non-sworn unit that they have established as well. It's always an honor and privilege to serve you. And by way of introduction, Ms. Westphal is one of the Deputy Attorney Generals in my office. She's one of 50 deputies spread across the state of California. We're in Fresno, San Francisco, San Diego, Sacramento, and Los Angeles. And Ms. Westphal has been with my section since 2014. And she served as a lead prosecutor for several years on behalf of this board and others to be able to manage investigations on your behalf. Prior to that, she served for more than a decade at the San Diego City Attorney's Office. So she's an exemplary Deputy Attorney General and one of our stars in our section. So it's my real privilege to be able to introduce you to her today. She will be providing the PowerPoint presentation on the enforcement process. So I don't want to steal her thunder. So obviously, if you have any questions for me, I'm happy to answer them. Otherwise, that concludes my remarks today.
Thank you. Thank you for coming. Any comments from board members? Any comments from members of the public who are currently present? Moderator, any online public comment?
This is the moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And it does look like we have a request from an individual logged in as Selena Alvarez. Selena, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Can I speak on the next one?
Yeah, I'll keep your hand raised, and then for the next agenda item, I'll call on you.
Oh, it's on 14. Sorry.
Okay.
Thank you very much.
Thank you.
All right. In that case, it doesn't look like we have any comments on this item. Would you like me to close that Q&A panel for now?
Yes. Yes, please. Okay, we'll move on to item number 14, the enforcement process presentation of Erica and then Carolyn Westfall.
Dr. Bahari, if we can have 5 minutes to just
You get set up, sure.
situate ourselves.
Sure. Let's take about 5 minutes to take a break so we can get the audio, visual, and everything set up.
Thank you.
Go. Okay, we're back in. So agenda item number 14, the enforcement process presentation. We have Erica Calderon, our Executive Director, Kathleen Nichols, our Chief of the Division of Investigation, and Carolyn Westfall, the Deputy Attorney General.
Thank you, Dr. Bahari. I'm going to go ahead and start us off. First of all, thank you, ladies, for joining me and agreeing to do this presentation on such a short notice here. I know that this is a request that the board has had for several years, and so I wanted to deliver it at this, my first meeting with you. We'll go ahead and start with reiterating our mission, and our mission of the board is to protect the public by requiring competency, accountability, and integrity in the safe practice of medicine by osteopathic physicians and surgeons. I am presenting this along with, like Dr. Bahari said, the Chief of the Division of Investigation, Ms. Kathleen Nichols, and Carolyn Westfall with the Attorney General's Office. Business and Professions Code 2450.1 gives the board the authority to protect the public. Protection of the public shall be the highest priority for the Osteopathic Medical Board of California in exercising its licensing, regulatory, and disciplinary functions. Whenever the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be its paramount. So what does enforcement do at Osteo, OMBC? We respond to consumer complaints, we conduct desk investigations, we impose a disciplinary action, and then we monitor the disciplinary action that is imposed, and that is through our probation program. I do have a couple of staff members present here today. We have 4 analyst, for Associate Governmental Program Analyst in the Enforcement Unit, Beth Dutchler. She is right in the front center. You heard from Corey Sparks, our lead analyst, who is going to be leaving us soon, but he is also part of enforcement. We have Robin Mattson and Steve Lai, who is also present here today. I mentioned earlier that one of the very first projects that I came to help with was the revamping of our consumer complaint form. Wanted to point that out for our consumers to give them an idea where they can find this consumer complaint form. So it's on our website, www.ombc.ca.gov, under the Consumer tab and under Complaints. We did mention earlier that we included additional instructions to this consumer complaint form, allowing the public a little bit more access to knowing what it is that we need to conduct our desk investigations. We added more spacing to allow for more details of the complaint, and then also instructions for them to include additional pertinent information that they may have in their possession at the time of submission that will be very extremely relevant for our desk investigations. We also added our releases. We did not have those releases attached. They were separate complaint documents in the past. And by doing this, we decided that it would save us some processing time of going back and forth. In addition, it allowed us to conduct more investigations than usual. Sometimes it's very hard to continue on with a desk investigation because we cannot obtain a medical release. Consumers will file a complaint and shortly after will go silent for a while and we are unable to locate them. So we figured by adding the release up front, letting them know that this is a very key important function that we need in order to proceed, that we would save some time and also allow for more consumer complaints to go through. So I wanted to go ahead and talk about the phases of the enforcement process. We have the receipt of the complaint, the desk investigation, which is the phase where we collect the medical records and all the evidence as stated in the allegations earlier, as I mentioned, we're talking about medical records, any text messages, any videos, recording, all of that is very pertinent. Police reports, court documents, and some of those sexual misconduct cases would be relevant. We also have the investigative stage, which is led by the Division of Investigations. And then we have the ability to go ahead and do cites and fines for minor lower level violations such as medical record keeping and or a failure to update an address or actually respond to the board for submission of evidence and records. We do have a pre-accusation PLR that we are able to utilize. And then we also have the process of referring our cases to the Attorney General's office for for actual filing of an accusation. And then we also have the ability to file with the DA's office for criminal prosecution in some of those cases. Examples of some of those cases could be our prescribing cases and or our sexual misconduct. So our complaints are received. It starts off obviously with patient care. Consumer finds that there's a matter that they are concerned with. They file their complaint. This can come directly from the patient, can come from a patient's family member, patient advocate, another licensee, also through mandated reporting such as an 801 report, which is the settlement and judgment or arbitration award, and also an 805 report, which is a peer review or health facility report. Other government agencies can also file these, such as Department of Public Health, the DA's office, law enforcement, CHP. We've had numerous departments filing as well. Anonymous and miscellaneous complaints do come through a lot. They are investigative. We just, for anonymous, sometimes we have a hard time moving it along, especially if there's very little information that's given to us, especially when it's pertinent information, such as a patient name, a date of when the incident occurred, or where the situation, happened. So we do not discourage them. We obviously move forward as much as we can, but they do tend to be a little limited in our abilities to proceed with. We do have a process called the initial initiation process of our complaints. We talked a little bit about our mandate. We have to initiate our cases within 10 days. We need to acknowledge them. They need to get entered into our BREEZE system to be, issued a case number, a control number, so that we can track our complaint. And in this process, we also have staff that are reviewing to make sure that we have that information and that we have, most importantly, jurisdiction to actually proceed. There are some non-jurisdictional issues that I have here listed for you, such as demeanor issues, wait times, or cost for services rendered. With that, I do like to say that we do proceed reviewing cases where there is double billing. The cost of services rendered is more so when there's a dispute between the client, the patient, and or the facility for an actual service that did occur where they were quoted one amount and then they were charged a different. There is also a process during the triage portion, and that is also to look for high priority cases. So we like to move those along very quickly. Some of the things that we look for are are sexual misconduct, patient impairment that deals with drugs and alcohol or mental conditions. In addition, if our licensee has already been placed on probation, we do like to move those cases along. There's obviously some underlying situation where they have already been placed on probation, and we just, for consumer protection, we need to prioritize those. So what does the complaint, what are some other keys that we look at that come into play? And that would be physician's history. Like I mentioned, are there any pending investigations already at the field with DFI? Those we like to move along, especially if there are similar allegations. If DFI is already leading a prescribing case and we have another one coming through, we do like to expedite that just so that DFI has the most information possible to move the case along. If there are any disciplinary proceedings already in place, let's say that there's an accusation already pending, if we have a new matter that actually has evidence to pursue, that we can pursue, we would like to go ahead and expedite that as well. The Attorney General needs to have as much information as possible because we do amended accusations. I mentioned earlier, what should we obtain? We should obtain medical records, police reports, court documents, a physician response. The physician has we actually have the authority, we are required to go ahead and request a response from the physician. There are some cases that we don't do that up front, and that is our high priority cases, so I do want to clarify that. But in some situations where it is a quality of care scenario, we do contact the physician. We also collect the records and obtain a written response. We do send our cases to a consultant review, and I mentioned earlier the need for us to promote bringing on more consultants, especially for those quality of care cases. Before they go to further investigation, they do require to be reviewed by a consultant. So the process again is we obtain the release and then we contact the physician for a treatment summary and we collect certified records. So what are some possible outcomes after that initial medical consultant review? We can issue a citation and fine for minor violations, and I mentioned earlier, failure to provide medical records, record-keeping issues, false advertisement, or we can refer the case for further investigation to DFI, or in some situations where it's founded that the allegations have no merit, we do end up closing the matter. I'd like to go ahead and turn it over now to Ms. Kathleen Nichols, and she'll go ahead and cover the investigation process.
Okay, so to walk you through the investigation process, the first thing that's done is that the investigator reaches out to the complainant, who sometimes is the patient, sometimes not the patient, but that's where we start. We like to do that within 30 days of receiving the case referral. After the witnesses are interviewed, we need to obtain, in most cases, medical records. Sometimes those are from multiple facilities, from the subject physician and maybe some post-op care or other treating facilities. We obtain those records by either a release or a subpoena. And then the third way we can obtain records is if it's a criminal case, we can write a search warrant to obtain the records. So you have to have one of the three, either a release from the patient, a subpoena, or a search warrant. And if the patient doesn't sign a release and we have to move towards writing a subpoena, you have to have good cause for that subpoena. So our process is we would then send the case to our in-house district medical consultant who would review the case up to date and then provide an opinion on whether there's good cause to proceed. And then if there is, then we subpoena the records. And a lot of times if the facilities don't give us the records after we subpoena, then we would refer that matter to the Attorney General's office for enforcement of that subpoena. They would work with our medical consultant, drafting declarations, going to court. So that's kind of that process for that. And then once all the records are received and we have everything, the case is reviewed by our district medical consultant. That's in preparation for the subject interview. They help kind of translate the medical issues for the investigator so that it's very clear before we interview the subject, what are the concerns, where are the parts in the records that we need to focus on. And then the next step is to actually interview the subject physician. We like to have voluntary interviews. We send out a request and we ask to schedule an interview at a mutually agreed date. A lot of times, sometimes we don't get a lot of cooperation and things get delayed. So at a certain point, we have the ability to issue a subpoena, a personal appearance subpoena to that physician, requiring their attendance at the interview. And then once we interview the physician, it would then be submitted for expert review in an expert of the same specialty of that physician. And going back to the interview of the physician, a lot of times in the interview, more information comes forward. Either the physician, they say there was another witness present, or they say there's other documents. So a lot of times there's other follow-up investigation that's needed after we've interviewed the doctor. And sometimes that involves going back to the patient or the complainant, because sometimes things are asserted, but we don't know whether that's true or not, so we have to go back to the patient and verify or obtain new information, with the goal of just completing that complete picture, so that when we send the case to the expert, they can review it fairly and they have all the information that they need. And then once we get the expert report back, then it's just a matter of reading that expert opinion. Did the expert find any departures from the standard of care? Were they simple departures or extreme departures? Do we have clear and convincing evidence to move forward? Because for our cases, it's clear and convincing to file an administrative case. For criminal cases, we would need a little higher burden of beyond reasonable doubt. So if we do think that there's enough, that would be our recommendation to the board. When we submit the case back, we will provide a recommendation. It's ultimately up to the board to decide, and also in consultation with the Attorney General's office of what their opinion is of the evidence that we've gathered. And then the types of violations and allegations, anything from gross negligence, incompetence, repeated negligent acts. That's when you have multiple simple departures that are separate and non-related. Also sexual misconduct, overprescribing, violating drug statutes, furnishing drugs without an exam. We have a lot of the aiding and abetting lately. That includes the corporate practice of medicine, where physicians might, get hired and get paid a few $1,000s a month to slap their name on as the medical director, but maybe they're not there, and there's all sorts of things going on. So a lot of those cases involve undercover operations, where we actually send investigators in posing as patients, trying to figure out what services they're providing, what type of licensed professionals are there. So that's kind of how those are investigated. Also, other types of violations, physician misconduct. They could be convicted of a crime, substance abuse, fraud, and then the series of 820 issues, physician mental and physical illness. If there's any question about a doctor's competency, we would obviously want to intervene on those cases early. And then minor, sometimes record-keeping violations is what an expert finds. And possible outcomes that the board is the one deciding what to do. They can issue a cite and fine. We can refer it for criminal action for the district attorney. They can issue a pre-accusation public letter of reprimand, or they could refer the matter to the AG's office to review for possible disciplinary actions. And then there's some interim actions that can also be done. PC-23, that's when there's charges filed in state court, where we can actually go in at that hearing and ask the judge to suspend the physician's license as a condition of their bail. There is notice that is required, that the subject has to be given notice, so that comes into play as well. Interim suspension orders, that's when the cases are so serious that we feel the public's at risk, it's a danger to the public, and if we have an expert opinion to support that, the board could pursue an interim suspension order. Also includes petition to compel. For example, if we had an impairment case and we had information that a doctor was impaired, but they refused to give us a urine test or participate in any evaluation, if there's enough evidence, the board could move forward with a petition to compel that exam. And then, of course, if there's no evidence that is substantiated at the end of the case, the other option is just to close the case. And then, like I mentioned in my update, this year we started a new non-sworn unit. The purpose of that was just to help some of the smaller boards that didn't really have the bandwidth to have their own non-sworn investigators as part of the board. So we converted 3 sworn positions into non-sworn so that they can help assist working some of the less serious, less complex cases that don't necessarily need a sworn investigator. Now, prescribing cases do go to sworn because a lot of times we need to get the original prescriptions and you have to be a peace officer to do that. But sometimes the quality of care cases where it's one patient, one medical issue, The non-sworn special investigators are very highly trained as well. They're very capable of doing quality, thorough investigations. Plus the added bonus of it being a potential cost savings for the board, because the hourly rate is less than the sworn investigators. So we're looking forward to just having that unit develop and seeing how it works for the board. Right now, it looks like the 3 positions we have allocated is enough to deal with the workload. So as we move forward, we'll be assessing that as well, just to make sure that their caseloads stay reasonable.
All right, I'm Carolyn Westfall. I'm a Deputy Attorney General out of the San Diego office. I carry a caseload for all the licensing boards we support, but I also serve as the liaison to this board. So I field questions from the Executive Director and her staff on legal issues pertaining to the enforcement actions. After the investigation is complete, the case is submitted to our office for legal review. We could review it and send it back, suggesting that additional investigation is required before we think we can meet our burden of proof. We might recommend some lower sanction, like a cite and fine or a public letter of reprimand for more de minimis allegations. But usually what we do is we accept the case, and we would file an accusation when we believe we have clear and convincing evidence to prove the physician engaged in unprofessional conduct. The accusation must be filed before the expiration of the statute of limitations, which for the most part is 3 years from the date the board learned of the event or 7 years from the event, whichever is sooner. Unless there's some other interim order issued, like that PC 23 or an ISO issued, the accusation would be the first public document that's posted on the board's website. The accusation is served upon the licensee, but it's posted on the website also to put the public on notice of the charges that have been levied against the physician. The accusation is the legal document that's laying out not just the charges, but the jurisdictions, so all the relevant statutes that are at play in the case, the charges, and then a factual sort of synopsis supporting the charges, and then at the end of the document is sort of the prayer, what we're hoping to achieve at the end of the case. A medical license is actually considered a person's property, and the government, the board, can't take the property without providing due process of law. So the accusation and the process that follows is essentially providing that due process to the licensee, giving them an opportunity to be heard before their license can be taken. After we file the accusation, the next step is to wait for the licensee to file a notice of defense. That's where they're contesting the charges. If they don't file the notice of defense, after a certain period of time, the board can proceed by default. And essentially what would happen is you would just revoke the license. If the notice of defense is received, then the ball starts to roll of preparing this case to go to hearing. So we exchange discovery. We would attempt, of course, to resolve the case short of a hearing. So the process of settlement negotiations would occur between the Attorney General and either the licensee directly or their attorney if they've hired one. Any settlement offer that we extend has to be approved by, of course, the Executive Director, and we would be relying upon the disciplinary guidelines as sort of a strike zone for any settlement offer that is extended. If we're unable to reach a settlement, we proceed to a hearing in front of an ALJ at the Office of Administrative Hearings. Our hearings look very much like any other court trial. There's no jury, of course, but usually there's attorneys on each side, and we comply with the rules of the Administrative Procedure Act. We call witnesses, we admit evidence, and at the conclusion of the hearing, the ALJ would issue a proposed decision that then is submitted to the board to vote on. The ultimate outcome in any case, of course, is up to the board. So all stipulated settlements and proposed decisions are presented to the board for your consideration. After reviewing all of the documents submitted to you, you then make the ultimate decision in a case. You can adopt our stipulated settlements as presented to you, or the proposed decision as submitted by the ALJs. Your adoption of these is usually the most common result, but the board certainly can reject a stipulation and send it back to the DAG and ask them to make a different settlement offer, or to just say the case needs to go to hearing. You can reject the ALJ's proposed decision as well, and you can make minor adjustments to the decision. You can send it back and ask for more evidence to be taken, or you can just simply non-adopt and hear the case or consider the case on the total record. So that's where you would receive the transcripts and you would ask for argument from both sides, written and or oral, and make the ultimate decision after you've considered all of that information. However we reach the outcome when a decision and order has been issued by the board, the licensee then has a couple of options available to them. They can accept the decision and move on, or they can petition the board for reconsideration. You had a long discussion about that earlier in your meeting. Usually a petition for reconsideration is filed by the licensee with a request to stay the decision, and the board usually would stay the decision for a period so that they can consider that petition. The board can then grant the decision, or grant the petition and file a new decision, or they can reject the petition and the original decision would stay in effect. Once that happens, the licensee can accept the board's decision and move on, or they can appeal the decision at the Superior Court, and that process is called a writ of mandate. The Superior Court then can grant the writ or deny the writ. If they deny the writ, the licensee can accept the decision and move on, or they can appeal that decision again in the Court of Appeals, which would involve a very similar process to what happened in the Superior Court. It's just at a higher court level. So eventually the board reaches a decision and order that's final. The decision will contain the outcome of the case. It could be a dismissal of the accusation. It could be the revocation or surrender of a license. But more often than not, it contains an order of probation with terms and conditions. The highest priority of the board, of course, is public protection. However, in your disciplinary function, when not inconsistent with public protection, you're also supposed to be attempting to rehabilitate the licensee. And so the terms and conditions of probation are specifically designed to accomplish both of those goals, to protect the public and to rehabilitate the licensee. The common terms of probation where we are seeking to rehabilitate the offender would be educational programs. There might be prohibited practices. You would see that in less egregious sex cases. Oftentimes we would prohibit a physician from seeing female patients, for example. You might see prescribing restrictions where they can only prescribe certain level drugs on the schedules. You might request a practice or a billing monitor. But importantly, every case should include cost recovery. The licensee is essentially on the hook for the cost of investigation and prosecution of their case. In the more egregious cases that don't rise to the level of revocation, we would be seeking a temporary suspension of their license for a specific period. And in less egregious cases, we would be seeking a public reprimand. All disciplinary outcomes that result in a public reprimand up to revocation, of course, are posted on the board's website. And in the very rare case where we've determined we can't meet our clear and convincing burden of proof, or for some reason it's determined that no discipline is warranted against a physician, an accusation can be withdrawn or dismissed.
Just to finalize the presentation here, we do report to the Federation of State Medical Boards, the National Practitioners Data Bank. We are hoping to establish a newsletter in the near future which outlines any and all disciplinary actions that we are going to be taking. So that is another project on the horizon for me. And we are also hoping to revamp our website here very quickly and provide more, essentially more transparency to our consumers. I'd like to point out, though, that we are mandated to upload these documents, like I mentioned earlier, and you can find those by doing a license search of your physician under the Administrative Disciplinary Actions. If you can see, there's a number located right next to it that says that there is a document attached to that, and then it would take you straight to either that accusation or that disciplinary packet. That concludes our presentation. Again, I'd like to thank both Kathleen Nichols for joining me today and Carolyn Westfall. Such a short notice to put this together, and I greatly appreciate them.
You know, we appreciate this. This is something we've been asking for quite a while. In particular, the website and what a complainant goes through to get their complaint uploaded and in, and then what the process was. That questions come up at a few of our board meetings in the past. So this was a very nice presentation. Any of the other board members have comment?
I just had a quick question. Thank you for that presentation. If at any point the original complainant decides to withdraw their complaint and your office is advancing the investigation, does that mean that that case would be closed, or is it on a case-by-case basis?
From the investigative side, even if a patient later on decides they want to withdraw their complaint, we will continue to move forward because a lot of times the departures are in the medical records and you wouldn't need the patient testimony. But say it was a behavioral issue or sexual misconduct, you are going to need that patient's cooperation in order to be successful. So we don't stop the investigation, we don't close the complaint, but at the end of it, then we make an assessment as to whether or not we have enough evidence to proceed without the patient's cooperation.
Understood. Thank you for that.
And from our position, my answer would be quite similar. Usually we don't need the patient's cooperation in a case. The evidence is usually contained within the medical records themselves. Even if it was a sexual misconduct case, if there are witnesses, if the doctor admits to any wrongdoing, we would certainly proceed. At the end of the day, it's a matter of can we prove unprofessional conduct by clear and convincing evidence, and we look at the totality of the evidence available to us to see if we can prove it.
Thank you.
I'll step in and add to that. At the board level, this is actually obviously once the case has been vetted that there's enough evidence to pursue an investigation. That's where Kathleen and Carolyn come in. But there are times that we do receive complaints where the patient may file it right there when they're visiting the doctor, and then the matter resolves the next day. And in those situations, as long as there's no allegations that we would be concerned about that would rise for us to, move the case along, we may consider closing it. An example would just be, the doctor was rude, possibly took 2 hours to see me, and then later on, there was a discussion between the patient and the doctor was running late because he was attending another patient. And sometimes those discussions do occur. And as long as we don't see anything else, any other, matters that are of concern, we may close it.
Thank you.
Any other comments from board members?
Yeah, just
Johnson, I just want to echo. Oh, sorry. I just want to echo what Dr. Buhari said, because we have been asking for this for a while, and it really, the transparency, the clarity for us so that we know the process better, as well as all of the work with the website, with trying to streamline some of the forms, such as the release and everything that you had been discussing earlier. That really helps, I think, the public to be able to proceed with any complaints that are there and know where they are in the process and what's going on. And thank you, Ms. Calderon, Ms. Westphal, and Ms. Nichols for your presentation. That was wonderful.
All right. Is there any comment from members of the public who are physically present here? Moderator, any online public comment?
This is the moderator, and at the direction of the board, I have opened up the Q&A panel for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And it does look like we have a couple requests for comment, so I'll go in the order that they were received. First is from Selena Alvarez, and Selena, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
Yes, hi. My name is Selena Alvarez. Do you hear me?
Yes, we can hear you.
Yeah.
Okay. Yes, hi. My name is Selena Alvarez. I am from Bakersfield, and I am a volunteer with Consumers Watchdog. I have suffered immediately. My doctor ignored my most extreme complications through my pregnancy, causing me to deliver my severe premature baby girl. My baby was airlifted to another hospital where I waited for months, not knowing if she would survive. But my baby girl did survive. They saved her. My beautiful baby girl was struggle with her injuries from her lifelong harm, and it has been heartbreaking to watch her struggle. My daughter cannot walk. She is on a feeding tube and she will need 24-hour care for the rest of her life. This could have been prevented. My daughter should not have to endorse this. I was so busy caring for her during the time that she was born that I did not know about the filing a complaint until I learned from it. And then I filed a complaint for my daughter. My daughter is now 8 years old. She is my miracle child. First, your board tried to tell us that it was not my OB's fault, but it was the pediatrician's fault. My advocator helped me fight that. Then, although we were told that my complaint will remain open, we received a letter closing my complaint citing that my daughters did not meet the exceptions to the statute of limitations for minor children. Children do not have the statute of limitations. They have an exception which allows them to have their complaint received and investigate until they reach the
15
age of
seconds.
18. This board told me that my daughter did not qualify because you claimed that she was a fetus and not a minor. I will ask for you to please reopen my daughter's case and do not let the board deny her rights as a minor or any baby's rights. Thank you.
All right, this is a moderator. We'll move on to our next individual. Individuals logged in as Tracy. Tracy, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
I'm a watchdog. I came here for accountability for my child and my grandchild. It is my responsibility to submit my complaint and follow it, and it is your responsibility to investigate deaths, and you are not. This board is violating the Business and Professional Code, Chapter 4, Article 5, Section 328, which requires that you investigate all deaths, complaints. Yet you have continued to deny my grandson the right to an investigation. I have pushed my complaint through your enforcement process for 1 year and 8 months. I have no control number stating that my complaint was received. This is telling me that you are not investigating his case. I am doing my part. You need to do your part and communicate with me. You need to interview me if my case is dismissed. You need to tell me that my complaint is just sitting or not moving for 1 year and 8 months and why. The bottom line is that my investigator with the medical board case lied to me, telling me that it didn't matter that the two cases, the medical board and the osteopathic board, were combined for the two doctors. Therefore, I was never interviewed by an investigator for my complaint against the osteopathic doctor. Yet this board came to a conclusion with no investigating from me. This should be a matter that overturns the decisions. You are denying babies the rights for investigation. Besides my grandson, you also have denied the 7-year-old daughter the right to be an investigation and the right to the exception to the statute of limitations for minors. Don't be a board that denies babies' rights. Lastly and leastly, Deputy Attorney General is weighing on these cases prematurely, requesting their
15
closure
seconds.
without entering the process. This is an issue that we request that the Deputy Attorney General's role in the enforcement process be placed on the next board agenda. Thank you.
Right, this is the moderator. We'll move on to our next individual. Individual logged in as Monique. Monique, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
Bakersfield and a volunteer with Consumer Watchdog. Thank you for giving us the opportunity to discuss the enforcement process with you. The stats you provide tell the story of how difficult it is to get accountability for tragic deaths from this board. I know this firsthand because this board has given us nothing but heartache in trying to file and follow a complaint for my grandson's tragic death. My grandson only lived, for 18 hours. He weighed in at almost 5 pounds. He died to maternal negligence. This board would not accept my grandson's death complaint. It has been 1 year and 8 months since we submitted his complaint, and we have absolutely no information as to where it is. What needs to change? You need to follow Business and Professions Code, Chapter 4, Article 5, Section 328, which requires this board to investigate all death and serious bodily injury complaints under the highest priority level. Give families the right to communicate with the board. Before you dismiss a quality of care death or serious bodily injury complaint, you must interview the complainant or surviving family member. In doing so, you will get the additional information you need to potentially move the complaint forward. Provide us information on your physician profile. We need to know the background of our doctors. If an 805 report has been received, note that on the profile, stating 805 report, loss of hospital privileges. If there has been a criminal charge, note that on the profile, stating 805 report, filed against a physician, note that on the physician profile as well with the actual charges. We need this
15
information
seconds.
to make the best decisions for our families. This board is denying rights to babies. My grandson was not the only baby whose right to have his death investigated denied. You also violated the rights of a 7-year-old Bakersfield daughter claiming the statute of limitations had run on her complaint, denying her the right to have her complaint accepted and investigated up until became of age. Our babies have equal rights as any other person, whether they live for 18 hours or are still alive today. Don't be the board that denies babies the right to an investigation. Thank you.
All right, this is the moderator. Our next individual is logged in as Xavier de Leon. And Xavier, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears in your device. All right, and you are unmuted.
Volunteer with Consumer Watchdog. I'd like to thank Dr. Jensen for bringing this issue to the board. Like I've said before, the enforcement process needs to change because it's not set up to provide rights for patients. My son is a prime example of this, having only lived 18 hours, but died due to the lack of care that him and his mother received. We have fought this board to accept my son's death, and it's been just under 2 years since we submitted his complaint and have done everything possible and yet still don't have a control or case number. And in my experience, this board is denying rights for babies to have their own complaint and investigations of their death and lifelong harm. I also believe that this board is violating the code 328, and my son isn't the only babies whose rights you have violated. Please move my son's complaint and many other families' complaints to investigation, and don't be a board that denies a baby's rights to an investigation. And lastly, we can't discuss enforcement without discussing the Deputy Attorney General and how they are calling for the closure of complaints without the complaint entering the enforcement process. We're calling on the issue of the DAG to be placed on the agenda for the next board meeting. Thank you.
All right, this is the moderator. We'll move on to our next individual, Maria Ibarra Navarrete. And Maria, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device.
I'm Maria Ibarra Navarrete. I am from San Jose, a volunteer with Consumers Watchdog. My brother died tragically due to medical negligence. His doctor committed a medication error which led to his death. The medical facility nor the doctor failed to report the never event to me, which means they didn't report it to you. They are required to report a never event. One of the problems with the enforcement process is the lack of communication with family members. I understand that the medical board is working on a complaint notification system. You need to implement one as well. We need more information from you. There are no email notifications when an accusation is filed against a doctor or when a discipline is taken against a license. I support the fathers and mothers on our team. You cannot deny the right to babies to have their deaths and lifelong harm investigated. I also support the movement to make this board follow the law and follow complaint prioritization guidelines, which requires you to forward all death complaints to investigation. Thank you.
All right, this is the moderator. Our next individual who has requested public comment, Michelle Montserrat Ramos. And Michelle, you'll be given 2 minutes to speak and a 15-second warning. Please click the unmute me button when the prompt appears on your device. All right, and you are unmuted.
Good afternoon. I am Michelle Montserrat Ramos, and I'm with Consumer Watchdog. I have the honor of working with these amazing families, trying to help them navigate through a complicated and broken process. I hope we can work together to improve this process for families. You are not following Business and Professions Code, which requires you to forward death and serious bodily injury cases to investigation. I know through my work with my team that you are closing many death complaints before they ever reach investigation. We need better communication with staff. Before a complaint is dismissed, we need staff to interview the complainant or surviving family member. I am working with our team to ensure that they are filing complaints with the Department of Public Health and other entities that back up their complaints. When we try to submit other investigation documents, please accept them. I have personally debated with staff and exchanged documents with staff for 8 months until they reopened a case. The documentation supported the complaint. I have much more to share with you that I will send in a letter. Please reopen the case for Bakersfield's 7-year-old daughter. She deserves the right to her own investigation, and she deserves the right to the exception for minors that all other minors are guaranteed. We are here to work with you and make the enforcement process better for everyone. Thank you.
All right, this is the moderator, and it appears that was our last request for public comment. Would you like me to close the Q&A panel?
Yes, please. And thank you for those comments, and thank you for the presentation once again. All right, let's move on to election of officers, agenda item number 15. I will pass it off to our Executive Director, Erica Calderon. No, we're doing all three. President, Vice President, Secretary. Yeah.
Good afternoon, Michael Knotes, Legal Counsel. I'm going to help you with your elections today. So we will be electing for the calendar year a board president, a board vice president, and a board secretary. So the way we'll proceed is we'll ask for nominations. We'll ask if there's a second. We'll ask for the nominee if they want to present any remarks, and then any discussion, and then we can vote depending on if we have more than one nominee for each position. It'll be a little bit different how we vote. So to go ahead and begin with the president office, do we have any nominations for the office of board president?
I would move to nominate Dr. Buhari as board president.
Is there a second?
I can second.
I'll second.
Couple seconds. Dr. Buhari, would you like to, do you accept the nomination?
Yes, I accept the nomination. And I just want to say it's an honor to serve and to serve with this particular board. We're giving, although it's not a huge time commitment, it is the time we spend with the board, I think, is very purposeful and important, and I think everybody's been taking it very, very seriously, and it's a pleasure to work with new members of our staff that have come on, and with Erica. And moving forward, we have a lot of projects in the future, and I hope to be a strong part of it. Thank you.
Are there any other nominations for board president? Any board discussion on the election of board president? And any public comment from folks in the room? Hearing none, any comment from individuals online?
This is a moderator, and at the direction of the board, I have opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close the Q&A panel?
Please. Can we call the roll, and it can just be aye or nay in terms of the election, since we only have one nominee?
Gloria Damian.
Aye.
Dr. Buhari.
I'm always embarrassed voting for myself for anything, but yes, aye.
Dr. Jensen. Claudia Mercado left. Andrew Marino.
Yes.
Dr. Patel.
Aye.
Denise Pines.
Aye.
And Claudia, I didn't realize you were still here, Claudia Mercado.
This is a moderator. Looks like Claudia's audio may be disconnected. Yeah.
Okay. We have a quorum. Okay. We have a quorum. Motion carried.
Congratulations, President Buhari.
Thank you very much. Thank you to all of you.
Are there any nominations for the position of board vice president?
I would like to nominate Dr. Elizabeth Jensen.
I can second.
Dr. Jensen, do you accept the nomination?
Dr. Jensen, I think your mic might be muted.
I do.
We hear you now. Is it? Okay. Are there any other nominations for the position of vice president? Hearing none, any member discussion? Any public comment from the room? Any public comment from members on WebEx? Members of the public?
This is the moderator, and at the direction of the board, I've opened up the Q&A panel for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. I'll go ahead and pause a moment to allow the public time to access that feature and submit their requests. All right, and seeing none, would you like me to close that Q&A panel?
Please and thank you. We can call the roll.
Gloria Damian.
Aye.
Dr. Buhari.
Aye.
Dr. Jensen. Dr. Jensen.
Aye.
Andrew Marino.
Aye.
Dr. Patel.
Aye.
Denise Pines.
Aye.
Motion carried.
Congratulations, Vice President Jensen. Moving on, are there any nominations for the position of board secretary?
Buhari, it's been an honor to serve on this board and to see all of the newer members come on, and I was very sad to see some of our prior members go off, but as Dr. Buhari and I have moved through, I know that there will be an excellent board in the future. And there are people who care and who are truly devoting their time and effort to this. So I'm honored to be part of that.
Okay, any nominations for the position of board secretary?
I would nominate Andrew Moreno.
I can second.
Member Moreno, do you accept the nomination?
Yeah, thank you.
Any board discussion? Any public comment from the room? Any public comment from members of the public on WebEx?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen or use the raise hand function. And I'll pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close the Q&A panel?
Please and thank you. And we can call the roll.
Gloria Damian.
Aye.
Dr. Buhari.
Aye.
Dr. Jensen. Aye. Andrew Moreno.
Aye.
Dr. Patel.
Aye.
Denise Pine.
Aye.
Motion carried.
Congratulations, Secretary Moreno. And if anyone wants to say a few words, that would be in order as well.
I'd just like to thank the board for the vote. I've been a member since 2017, and also as a public member, I appreciate the opportunity to serve on the board as your Secretary-Treasurer. Thank you so much.
All right, so that will conclude the election of officers portion of the agenda. We'll go to item number 16 on the agenda, which is the future agenda items and future meeting dates. I think a couple of items. One item was brought up earlier about the licensing, right? Interstate licensing. So we'll see if we can add that. And Claudia's right. They had made a couple of presentations to us. We never made any votes or any movement on it, but there were presentations from them in the past. So it would be useful to have them come back and maybe have some discussion with the board that's a little more meaningful.
In Claudia's absence, she did send me two recommendations for the next board meeting. One was a briefing on the current issues facing children's health care and access and lack of critical care physicians statewide. More specifically, finding experts to address children's health care issues.
Yeah, it may be an informational session. I don't think we have a lot of purview in that. Anything else as far as future agenda items?
Regarding the interstate compact, if you need help with the speaker, let me know. I can, not me, but I can connect you. The FSMB president did a pretty good talk at where I work, so it's a really good speaker, so we can invite him or consider that. So just let me know if you need help.
Thank you.
And then let's talk about future meeting dates.
Last year, you agreed upon a few meeting dates for the 2023 calendar. So as it stands, we have a meeting on May 11th, hybrid. August 17th, also hybrid, but tentatively being held at Western University down in Pomona. And then December 7th, another hybrid meeting, all on Thursdays.
Did everybody check to see if they had any conflicts to those last 3 dates of this year? I think we hashed it out last time pretty good. I think let's keep it like this for now. Before scheduling 2024, right? Okay. Good, but it's a little far. It's a little far ahead to be able to plan.
Could I just sorry to rewind, but just maybe one more item for consideration on the agenda for next time. I'm involved with the ACCME, so they do accreditation for CME, and a lot of organizations are becoming ACCME certified, including osteopathic organizations. If our board grows and expands as we'd like it to, I expect, or I can see us kind of doing talks that would qualify as CME. So one thing that we could consider as a board is becoming ACCME certified and pursuing that. Just a thought, something to maybe consider as a future agenda item.
We can go ahead and add that to the agenda.
And we can look into that.
Mm-hmm.
All right. Any public comments from public members in the audience? No? Any moderator, any online public comments?
This is the moderator, and at the direction of the board, I've opened up the Q&A feature for public comment. Members of the public, if you would like to make a comment on this item, please click the Q&A icon located at the bottom right-hand corner of your WebEx screen, or use the raise hand function. And I'll go ahead and pause a moment to allow the public time to access these features and submit their requests. All right, and seeing none, would you like me to close the Q&A panel?
Yes, please. All right, Erica's first meeting.
I'm done, right?
Yeah, you did pretty well, actually. Usually we start at 10, so if we had started at 10, this would be 4 o'clock now. We'd all be really exhausted. So I think starting at 9 is probably a good idea for the length of this meeting. And we didn't have petitioners. If we had petitioners, it would have been even longer. So, but I appreciate everybody's involvement. I think it was a pretty good meeting. So with that being said, next time, Machiko, we need a gavel to finish this off, please. All right, we'll go ahead and adjourn the meeting. Thank you.
Thank you.